I hand over to you to proceed.
Thank you, Honorable Chair. Mr. Pillay, good afternoon.
Good afternoon.
Yes. Yeah, I hope you had some time to reflect over lunchtime. Yeah, I'm a bit worried. You know, if you carry on like this, there's going to be two problems. One will be around finishing this cross-examination. The second one is that I'm going to argue at the end that your evidence should be disregarded because you are refusing to answer my questions, even the simple questions. So I think let's try, maybe after lunch, we'll make some more better progress. Okay? Yeah, I was saying to you, and I said I'm not going to move from this point because it's quite crucial for this whole entire process. This whole issue, the first issue that you and I dealt with, which is the status of judgments as opinions, but also this one now of where there are clear and blatant and patent errors in a judgment, which just at a factual level where one doesn't need to be a lawyer to pick up. These are going to be very, very monumental issues in this process. So I want us to work together. Can you go back, operator, to paragraph 113? Where we were before lunch. Yeah. So I'm saying, Mr. Pillay, this really should be a simple exercise. What the judges said there, the public protector relies on this report despite explicitly stating that she has not seen the report. You and I have agreed that that statement is wrong. Or at least, according to you, you've said something differently in relation to Mr. Van Lochenberg. Do you therefore agree that that's statement, do you disagree with that statement? Or do you agree with what it says, that in the public protector's report, there's anywhere where she explicitly or otherwise states that she has not seen the report?
Chair, I've gone on oath to talk about a coy denial. I do not mention explicitly. And the judgment states explicitly. And I'm sure, and I'm sure that the public protector will appeal that matter. That's
No, that's fine. Thank you. That's true. But for now, the public protector is not the one on the stand, on the witness stand. I'm asking you, do you, on your knowledge, and since you have given a different version, do you agree that that statement is factually incorrect? Or do you say it's correct? It must be one of the two.
Chair, I would like to see when the matter comes to appeal, I would like to see the arguments advanced by the public protector. And
no, it's not a legal issue, Mr. Pillay. It's not a legal issue at all. It's simple. It's eyes, you know. Whether she said she didn't see the report, any human being will be able to do that. Do you disagree with the version that in the IGR report, she had not seen the report? You could be a carpenter. That's just a simple question. It's got nothing to do with being a lawyer.
So I believe she relied on the contents, and she said she had it on good authority.
Yes, no, we'll come to that. But let's. I'm saying, do you agree or disagree that there is nowhere in the report where she explicitly states that she has not seen the report? We'll come to the good authority.
Chair, that is possible. I can't remember what was said, but when we said at the time that it was a coy denial, we did not say it. She explicitly stated that she had the report.
Yes, you did not, because that would have been false.
Because we didn't know that.
No, but you had the report. What do you mean you didn't know that?
At that time, we did not know that she had the report. We believed she had the report.
Okay. Now that you've seen the report, do you agree or disagree that that statement is incorrect?
Possibly incorrect.
Possibly, only?
Yeah.
Yeah. All right. And then let's go to, and therefore then, if you go to 115, please, operator. Says, the charges now say, despite the fact that the public protector, according to the report, has never seen nor verified the contents of the findings of the IGI report, she ordered the Minister of State Security to implement it within 90 days. So that must also be incorrect, right?
Yeah, it may be incorrect.
Maybe. Okay, we'll get there slowly. Go at 116. Go to 116. The judges say, and you'll be happy to know this is the last one. It is difficult to understand on what basis these sections of the Constitution can notionally grant the public protector to grant, or rather the power to rely on a report that she herself has not seen, because this is what she says in the report. So this must also maybe be incorrect, maybe.
It follows. It follows.
It follows, yeah. So if the other one is more than maybe incorrect, this one is also more than maybe incorrect.
Yes.
Thank you. All right. Well, there are many other examples, but I just wanted to deal with you with the one that involves you. Now, you would therefore agree that if a conclusion that's based on the wrong facts cannot be implemented, I mean, it's not, then it must be disregarded. In other words, if I say Mr. Pillay is in Australia, any other conclusion that follows from that will be wrong because you are actually in Europe, aren't you?
Yes.
Thank you. And that would be the danger of swallowing line, hook, and sinker a judgment just because somebody typed words on a piece of paper, correct?
That's a sweeping generalization.
Okay, let's be, okay, sorry.
Take one incident or one issue and say that the whole judge.
Yes, no, fair enough. But let's assume then this was the only issue in this judgment, was whether the public protector says she has seen the report. Then you would agree that then the judgment would be worthless.
No.
Even if it was just the only, let's say the only issue that was taken to court was simply whether or not the public protector says in the report that she has seen the report, and the judges got it wrong, as you and I have just discussed, would that judgment still be enforceable or rather worth the paper that it was written on?
My understanding is that the public protector denied that she had the report. It's coyly denied that she had the report.
That may be so, yeah.
And when the matter goes to, if and when the matter goes to appeal, I imagine that aspects of a judgment may be adjusted. And that is up to the court there to make an evaluation of the whole judgment.
Yes, fair enough. No, but okay, that's fine. So, and if the court denies the opportunity to challenge the judgment?
Then my understanding then is that the judgment is final.
Then that's it. Then it means It means even if you have the report and you can see that it doesn't match these what is said in these conclusions, that's it. She must just live with it for the rest of her life.
Chair, we're getting into the into a speculation. I think there's leave to appeal. You're going to appeal. Let us see what happens, and it might be that in the appeal that the judgments are adjusted.
Yeah, no. Okay, that's fine, Mr. Pillay. I'm just saying, I'm trying to talk to you not at the level of lawyers, just as a human being, person to person. If it happened to you, I'm just saying, let's say there was a judgment that said Mr. Pillay is a child molester. Sorry to use such a strong thing. And it was wrong. It's just factually wrong. You know that it's wrong. We all know it's wrong. I know it's wrong. You know it's wrong, and so on. I'm just saying, and then the court doesn't give you, let's say, the leave to appeal. What must you do? Can you then be removed? Let's say you are working at a school. Can you be removed as a teacher at that school on the basis of that clearly wrong finding that says Mr. Pillay is a child molester? When we all know, everybody in the country will agree that you are not, but it just happens to be typed in a judgment. Everyone will agree, but simply because it's typed in a judgment, you must then not be a teacher for the rest of your life. That's what I'm trying to say to you. Is that what must happen?
Chair, I believe I've answered many times.
Okay.
And my answer stands on that. If it's an analogy and one thing is found wrong and everything else is still right, that puts a different complexion. If many things are found to be wrong, it puts a different complexion on things. Personally, I'm the last person to be unfair to the public protector. And in fact, the case I'm making is that the public protector has been unfair to me. She has consistently not listened. She has consistently accepted a particular version, unquestioningly. And that's the point I'm trying to make. I accept that people make mistakes, but I want to say this, that a person in authority, serious authority, there must be a higher bar on such a person to get it right.
Yeah.
That is my understanding. And
yes.
The argument that this is a human being and she's going to get it wrong, I understand. But I think what I'm pointing out is that is a pattern. I'm saying that there's a pattern of behavior. It's up to the committee how they weigh all of these things.
Yeah, no, I understand that. And on the same vein, you would agree then that these paragraphs that I just sent you were also human mistakes on the part of those judges.
Oh, it's possible. People make mistakes.
Yeah,
they make mistakes, and one looks overall at how many mistakes are made, what types of mistakes are made. Is there a pattern? And then one pronounces.
Yeah, no, fair enough. No, that's why. Yeah, to be fair to the public protector, that's why she actually insisted that we should ask that there would be 3 judges in that case, because it was quite a complex case. Just so that these, what we call quality control issues don't arise. Yeah. But yeah, no, I agree with you. People make mistakes, and if they do, even if they are so glaring and fatal on other people's careers, that's what happens. We're all human. Okay, no, that's fine. Now, If we can just want to you accept then that the so-called rogue unit, one of the main issues there was the fact about the transgression of the intelligence laws of South Africa. In other words, most, if not all, of these people who found it to be illegal were saying so because it was performing functions which should be exclusively performed by the National Intelligence Agency, correct? We might have been wrong in that conclusion, but that was the gist of the illegality or criminality that was alleged against you, correct?
Yes, and confusing what was originally conceived and what finally happened.
Yes. If you go to operator, please, bundle E, page 817, item 1.1.
Can you repeat that for Tsepo?
Yeah, thank you, Chair. Bundle E, page 817, item 1.1.
Thank you.
Thank you, Chair.
Is that what you're looking for, Advocate Mpofu?
Yes.
Being flighted?
Yes, thank you. Just go down a little bit. Okay, that's the indictment against you as accused number 1 in the criminal case. Number 2 was Mr. Van Rensburg, as you say. And the number 3 was Johan Hendrik van Lochrenbeck. You remember this?
Yeah.
Next, and it says the 3 of you are guilty of the following crimes, or are charged, let's put it that way, of the following: contravention of section 49(1) read with provision section 2, and so on, of the Regulation of Interception of Communication and Provisions of Communication-Related Information Act. That's you and Mr. Van Rensburg, accused number 1 and 2. Next one, contravention of section 10 of PRECA, Prevention and Combating of Corruption Activities, in that you unauthorized gratification by a party to an employment relationship. It's the one about what Ms. Bauer called the employment issue. And then contravention of PRECA as an alternative. And then just carry on. Okay, you can pass that. That one is about the SARS Act. I want to go to, the one about the NSI Act. Just carry on, please. Yeah. So this was about section 1 of the National Strategic Intelligence Act. It says that the established national intelligence structures as the Intelligence Division, South African Police, and the agency. What is being communicated there is that there are only 3 structures that have intelligence capability, and that you and Mr. Van Lochrenbeck and the others breached that law by establishing the rogue unit. Do you understand that?
That is what it says. We didn't establish a rogue unit. Go on.
Yeah. And just go to the last page, please. Very last page with the signature. Okay, that's signed by an advocate, JP Pretorius, SC, Acting Special Director of Public Prosecutions. Can you see that? And again, you say this is all made up.
I say that it is not true that the unit was founded unlawfully, number one, and number two, I say that we made representations to the NDPP and the NDPP withdrew all of those charges.
Yes. No, but that's, you know, that NDPP withdrawing charges doesn't mean that you are not guilty. Just means that they might not have the witnesses that they need, but it doesn't really mean you didn't do it. You know that?
I know that the allegations also do not mean that I did it.
No, of course. But you also agree with me that it also doesn't mean you didn't do it.
It's possible, but what you are saying and what I'm saying.
No, but it's different. Me, I agreed with you fully. You are only going to go first to say it's possible, whatever that means. But that's fine. I'll take that as the best I can get. Okay, just go to the summary of facts, please, just after this. So this is how the National Director of Public Prosecutions saw the matter. And it says the accused persons, including you, were members of the Enforcement and Risk Division within SARS and were managed by accused number one, that's you, who was the general manager of the division of SARS. Accused one, you, reported to the Commissioner of SARS, and accused two and three reported to you. Accused two were employed special officers and so on. Then two, the Enforcement and Risk Division of SARS under the leadership of accused one, Mr. Pillay, produced a memorandum which was signed by Mr. Pillay and Mr. van Rensburg in February 2007. The memorandum was directed to the then Finance Minister, Trevor Manuel, and was requesting funding of intelligence capability within NEA in support of SARS. The purpose of the memo was to seek approval from the minister to fund special capability within NEA to supply SARS and the law enforcement with the necessary information to address the illicit economy. Illicit economy refers to the importation of counterfeit goods, illegal harvesting of abalone, and smuggling of cigarettes, and the importation of transportation of drugs. The memo was recommended by the Joint Commissioner of SARS, Pravin Gordhan, on 8 February and approved by Deputy Finance Minister Jabu Muleketi. The then minister signed his approval and request on 22 February 2007. The memo recognized that collecting tactical intelligence invariably meant that organized crime syndicates had to be penetrated to unearth their activities from within SARS, which was losing a lot of revenue. This was an activity for which SARS did not, at the time, have the capability, including the legislative mandate to manage clandestine activity. Let me just pause there. You agree that that's what your memo said, that the intelligence, tactical intelligence capability that you were looking for was something that you were not entitled to do in law?
That is why we wanted to do it with NEA.
Absolutely. Thank you very much. And that's where the problem is. You ended up doing it on your own.
That's an allegation.
Yes, it's an allegation, but I'll give you an opportunity to respond to it. Then it says the memo also informed the minister that discussions were taking place with the National Intelligence Agency to supplement SARS intelligence capability. It further stated that NIA was willing to create a ring-fence capability provided that funds were made available to cover personnel costs. It indicated that NIA was willing to formalize these arrangements in an MOU and so on. So far, you agree that that's what you were requesting for the reasons stated, correct?
Right.
Then let's go to the last one, paragraph 4. In 2004, a member of the high-risk unit of SARS with the assistance of accused number 2 commenced installation of equipment at the offices of the Directorate of Special Organizations and the National Prosecuting Authority. In September 2007, accused 2 instructed the meeting with the DSO that meetings of the DSO and the NPA should be monitored. This happened with the knowledge and approval of accused 1, that is you, Mr. Pillay. Both accused 1, Pillay, and 2 placed members of the high-risk investigating unit, that's the rogue unit, under the impression that the authorization required in Act 70 of 2002 was obtained from then President Mbeki. Various communications and meetings in the DSO were intercepted without the interception direction issued by the designated judge in terms of RICA. Conversations among members of the DSO during September 3rd, November 2007 were monitored, recorded, and transcribed without an authorization from the designated judge issued in terms of RICA. These recorded conversations among members of the DSO were handed to both accused number 1, that's you, Mr. Pillay, and 2 at their insistence. Accused 1, Pillay, even gave witness 13 an assurance, sorry, just want to check who's witness 13. That's Mr. Helgard Lombard. You know Mr. Helgard Lombard? Eh?
Indeed, I do.
Yes. He worked with you in the so-called rogue unit. Oh, okay. I'll take that as a yes. Silence means consent. Okay. These recorded conversation among members of the DSO were handed both to accused number 1 and 2, rather. Accused 1 even gave witness 13 an assurance that if these interceptions were discovered, he, that is you now, Mr. Pillay, will take full responsibility for having given the necessary authorization and guaranteed the members involved legal assistance that will arise therefrom. So Mr. Lombard will say that, or rather said that you gave them the assurance that you take full responsibility and give them legal assistance. Do you take full responsibility for asking them to bug the NPA?
Through the chair. Chair, I did not ask anybody to bug the NPA, and these allegations are untested.
Right. Then it says, after the security and surveillance equipment were fitted at the office of the DSO, do you accept that at least there was spying equipment at the NPA, which was installed? Let's say not by you, but that, as a matter of fact, there was such spying activity.
I don't accept that. What I am aware of is that the DSO requested for certain equipment to be put at their premises. Mm-hmm. They requested it of people who were working in SARS. Yeah. Help them to put it.
Why would... I'm sorry.
These people had a company. They were known to the DSO. Mm-hmm. And they requested them to do it. And my understanding is that it was all done after hours.
I see. So by day, they were members of the so-called rogue unit, and by night, they were putting spying equipment at the NPA. So, and you are saying those two things were not related?
So the only rogue unit I know is the rogue unit of the SSA. So you're talking about the SARS unit
Yes.
Yes.
No. Sorry. When I say so-called rogue unit, I know for it. Sorry, you call it the high-risk investigating unit. Yeah, I'm just calling it for what it is.
Yes. For what it is, the rogue unit is the SSA. So.
Right. Okay, then not that rogue unit. Your rogue unit.
No, I don't. Don't accept that that it is the rogue unit. It has implications for lots of people who were members, people who did lots of good work, and it's unfair to tarnish everybody, just as it is unfair to have broken a whole institution because of these allegations.
Yeah, well, that's true. Well, that's exactly, we feel the same about the public protector. It's unfair to break an institution in vain. But yeah,
really compare. You really can't compare the two.
Well, you can't. Which one is better, the public protector or the rogue unit?
No, I don't mean in that sense. You can't compare the two analogies. We've been under the cosh for years now, and it still continues. And what the public protector is experiencing in our offices, experiencing.
The Sunday picnic.
Yeah.
Right. Okay. Well, we'll see about that. Okay. Then after the secure. Okay. No. Sorry. We were at a point where you are saying that there were members of, let's just call it the unit. Let's use a neutral word. There were members of the unit who at night were bugging the NPA, or I'm sorry, were supplying equipment, whatever you call it, to the NPA for spying.
No, no, that's not what I'm saying.
Okay, what are you saying?
I'm saying that there are people in SARS who provided a service to the DSO.
Right. But that doesn't make sense. Why would SARS provide service to the DSO? I mean, that's the NPA is
it was not a service provided by SARS as SARS. They approached individuals that they knew who happened to be working in SARS. And they knew that these people had experience in the provision of equipment, and it was for the purposes of the DSO.
I see. So and these people happen to be the members of the unit.
Yes.
Yeah. No, but yeah, we're saying the same thing. So effectively, what you're saying then is members of the so-called rogue unit or the high-risk investigating unit were asked, because they were known to be involved in this kind of thing, they were asked to provide this type of surveillance or spying equipment against our national prosecuting authority. I mean, isn't that almost treason?
That's not what I said.
Okay, what did you say?
I said that a private company provided those services to the DSO on the request of the DSO. That's what I said.
Okay. And was there a reason why this was done at night?
Because
by this company?
Because during the day they worked at SARS.
In the unit.
Yes.
Okay. All right. And then it says, yeah, after security surveillance equipment was fitted at the offices of the DSO and NPA, an amount of 100,000 rand remained, and accused number 1, that is you, and 3, that's Mr. Van Lochrenbeck, authorized the members of the high-risk investigating unit, otherwise known as the rogue unit, to keep the money as if it was a private installation. Oh, that's what you were saying just now. Yeah. Thereby giving him gratification, which was not due to him. That is you. Accused number 3 also gave the member an authorization to perform private work after the work was completed in order to make the gratification to appear regular. This is almost like, it's what's called laundering or trying to ex post facto to justify this treasonable conduct. You understand the accusation. You may not agree with it.
We deny it. We deny that we were involved in anything
Of course.
unlawful. SARS was not involved in any in the financial transaction. That was between members of the DSO and a private company. And I think I've answered this matter.
Yes. And just to try and save time, if you could just carry on, please. List of witnesses. So the witnesses was a range of witnesses ranging from the Commissioner for SARS to Mr. Vusi Piccoli, Advocate Menzi Simelane, just keep rolling. Just Elkhad Lombard, Dival, these are the members of the unit, correct?
What? Yes, but what does this have to do with the matter at hand?
Which matter at hand? Well, the matter at hand is the rogue unit, sir. Well, that's what we were discussing with Advocate Bauer. That's the one we're discussing now. Thank you. All right, can you keep rolling? Yeah. And Mr. Michael Piacha, do you know him?
I know of him, and I know him to be somebody involved in poaching, and we've...
Rhinos.
Yes, and we discharged him from SARS. And I think after that, he began to work for the SSA for a while, and he also worked for cigarette companies.
Yes, but when he was doing rhino poaching is when he was a member of the unit.
Yes, and that is why he was discharged from SARS. And he...
So they could bug the NPA, but not poach rhinos.
The NPA was not bugged. The NPA was assisted.
They couldn't assist the rhinos. Okay, no, that's fine. Let's keep on rolling. Then the next one is, okay, then we have Mr. Trevor Manuel. Those are the list of witnesses. Advocate Herinel. Yeah, it's a who's who. But as you say, at some stage, the charges were withdrawn. And we've both agreed that means nothing. Whether it doesn't say you did it, also doesn't say you didn't do it, correct?
Correct. It's just as the allegations mean nothing.
Oh, yeah, please remove the list of people. Thank you. Thank you, Advocate Bauer. Right. Yeah, yes. No. I agree with you, Mr. Pillay. Yeah, they're just allegations. But at least we agree that the bugging did happen, but it was after hours, and
it's not the bugging. It's not the words. I would not use the words bugging.
What words would you use about putting listening equipment in the NPA?
The NPA requested
to be bugged.
They requested equipment to be placed because they felt they needed it.
For what purpose?
And that's the question you've got to ask the NPA.
No, but you're the one who said you're going to get them lawyers if they get caught.
None of these things are tested. And in fact, the point made in the judgment is that the public protector didn't test any of these things.
Yeah, okay. Anyway, that's so much for the rogue unit. By the way, you are aware that the equipment of the rogue unit is now being returned to the public protector, that Mr. Kisweta has invited the public protector to observe the handover.
I'm not aware, and again, as I say, it's not a rogue unit, and secondly, there's no equipment. There's no equipment. By the way, your favorite report, the Skakani report, says there's no equipment.
Also, To that extent, Sikakane was correct.
Well, even he will happen to be correct on some occasions.
Yeah. Well, okay. Maybe we'll call him as a witness.
Please do.
Yeah, but we'll also call the members of the rogue unit if we have to. We're only speaking to one so far, but we'll inform the committee. Well, excluding you and Mr. Van Lochenberg.
But really, the question is this, Mr. Chair, is why didn't the public protector do that work then? I think that's the issue.
She did. She spoke to Mr. Manyike, and she spoke to you. She spoke to many members of the rogue unit.
There's no affidavit from Mr. Manyike.
Well,
No
so
affidavit.
what? So what does that mean?
We made affidavits, and what we have put is evidence.
Yeah, she didn't use the same method to speak to members of the rogue unit. Maybe you were the lucky ones, but that's fine. Let's go to the retirement issue. We'll come back to this just so that I don't run out of time. No, let's start with the matric. You have a matric certificate?
Yes,
Where is it?
I have it
Where?
at my home.
Did you give it to the evidence leaders?
Evidence leader never asked for it.
Okay, and neither did the public protector ask for it?
No. She asked me if I had a matric. I confirmed. She asked me if that's what I told SARS, I did. And if my memory serves me right, I did provide SARS at that time.
Yes. Yeah. No, she did ask for it, but in fairness to you, maybe she didn't ask you, maybe she asked SARS, yeah. But her evidence will be that she asked for it, yeah. I'll find out just now. And by the way, I have no problem with your matric certificate. For the purposes of whatever I'm going to ask you, I'll assume that it exists. But you see, the problem is that it's one of those issues. It's just a red herring. If we were not in a formal hearing, I would use a different description. It's really, I mean, just a deflection, maybe the most polite word. Because the point is, for now, let's assume you have a matric. The point was not whether you have a matric certificate or not. The point that the public protector, and you know this, was making was that somebody who only has a matric qualification under normal circumstances cannot be the commissioner of SARS. I mean, surely, I mean, I know you might be what somebody described as an organic intellectual, but under ordinary circumstances, surely you'd agree with me, Mr. Pillay, that I'm not saying it's impossible, but it's unusual. Would you agree? I
agree. It's unusual to have a president like the one we had, but we came from unusual circumstances.
Yes, no, that's true. In fact, there are three examples. It's the former president and you and Mr. Hlaudi Mutseneng. But the other two got to where they were because of political connections. How did you get there?
Hard work.
Okay, so you are even better than the others, because I think even they would accept that their ascension, unusual ascension, was politically driven, obviously in the case of the president, but yours was just pure hard work.
Mr. Chair, I think I must point out here, I didn't appoint myself.
Yeah.
I think these are questions you should ask the people that appointed me.
Yeah.
And what I do know is that we went through tough assessments during our period in SARS. We had something called the goodness of fit, which all of us, except the then commissioner, underwent. And I have the results of that goodness of fit assessment. And it was the result of a 4.5 days of assessments that were conducted. I have the results, and the results are available. If you want to see it, I will send it to you.
No, I believe you.
So,
but I'm just saying that at least we've agreed that it's unusual. It's something quite remarkable. I mean, taxation is a very complex subject. For you to rise to the top of our tax system in this sophisticated economy, armed with a matric certificate, is something remarkable. And I'm saying, I mean that. But I'm just saying that you would agree that it's not your usual occurrence, everyday occurrence.
Chair, I must point out again, these things happened after 1994.
No, even after 1994, I'm saying still unusual.
It's unusual, and I didn't enter SARS in a senior position. I entered in a mid-ranking position. I know somewhere it says chief of criminal investigations. I wasn't a chief. I was a general manager of criminal investigations, and I managed 300 people. And I worked in SARS for 15 years. So,
no, I'm sure there are many other matriculants who've worked there for 15 years or 20 years. I'm just saying they wouldn't rise up to becoming commissioner for SARS or acting commissioner for SARS.
Well, I think that there were circumstances to that. I didn't think I would be acting commissioner. And I had no wish to be acting commissioner. And by the way, when I was made a deputy commissioner, my first action was to actually refuse it.
Yes. Okay. No, that's fine. So let's leave the acting issue. Let's deal with the permanent position. You would agree that it's still unusual to be deputy commissioner of SARS with those credentials?
It is.
Thank you. No, that's fine. Now, you and Mr. Godan have been friends for almost 50 years, correct?
I wouldn't say we are friends.
What would you say?
We were fellow activists in Durban before I went into exile. I really did not know him well. I only met him on a handful of occasions. I then met him in the underground after 1977 on a few occasions inside South Africa, and then on a few occasions outside South Africa when he came through illegally into Swaziland. So it is we got to know each other better in the underground. I still wouldn't say that we are friends, we were comrades.
Yeah, well, friends can also be comrades, but that's fine. Let's. So you've just known him for all those years. You're saying you were involved in illegal activities.
In the ANC underground.
Yes.
Yes.
That's what I'm talking about.
Yes.
So it was not the first time you were working clandestinely.
What are you referring to?
No, I mean now when you and him agreed to form the rogue unit, it was not the first time that you were involved in clandestine activities.
No, I do not agree with that. And the conclusion that the unit was unlawful is not founded in law and in fact.
Okay, that's fine. Then, Mr. Godan and you, let's just say you were whatever comrades involved, and you've known each other for more than 40 years, just to be rough about it. Correct?
Correct.
And your evidence is that apart from the hard work, all that had nothing to do with your meteoric rise in SARS to be Deputy SARS Commissioner.
I really don't think so. As I say, I said to you when I was first told I'm in line for Deputy Commissioner, I did not, my inclination was not to accept it. And it's the reason why I've never stood in line to be Commissioner.
Yes. No, I accept that, Mr. Pillay. I really do. I was asking you a different question. Yeah. I'm saying, are you telling this committee and South Africans that your decades-long relationship with Mr. Godhan had absolutely nothing to do with your miraculous rising to becoming Deputy SARS Commissioner armed with a matric certificate?
If you ask me, I would say I earned my place. We ran a world-class institution.
No,
and I'm not spinning words. By any measure of performance, we ran a world-class institution, and we cannot. If this is what happened, that people handed out in SARS senior positions to anybody who is not capable, SARS would not have performed at that level. It's impossible. It's impossible for performing organizations to be just appointing people that are not capable.
No.
It will show in the performance.
Yes. No, Mr. Pillay, I think we're talking at cross purposes. I have no doubt about your performance capabilities. I'm sure they are superlative. I also have no doubt about the performance of SARS at the time when you were there. That's not what I'm asking you. I'm asking you whether you seriously say that anybody must believe that your miraculous rise to what you and I have agreed was unusual had nothing to do, whether you are capable or not is a separate matter, had nothing to do with your 40-year relationship with Mr. Godhan. Yes or no?
Yeah, I would say it has nothing to do with it. And if anybody knows Mr. Godhan,
I don't.
Yeah, the people that he drives the hardest are the people around him. And there's no easy road, there's no soft job that Mr. Godhan gives to people.
Yeah, no, even that I'm prepared to accept.
So when there was an opening in SARS, I applied for it. I was assessed. I went for an assessment then. I was interviewed. I got the job. I wasn't even on the executive of SARS when I joined SARS in the first few years. And
no,
so,
fine.
but that is my explanation.
No, Mr. Pillay, I accept that you are exceptional people. I mean, Mr. Godhan was only a pharmacist as well, and you guys performed so well. Congratulations. But I'm simply saying to you, okay, I think you've heard what I've said. You haven't answered it. That's fine. Let's move on. Is it also your evidence that your so-called retirement had nothing to do with your relationship with Mr. Godhan?
Yes, it has nothing to do with Mr. Godhan.
I see. All right. So, but Mr. Godhan, it is true that Mr. Godhan, when this idea first saw the light of day, you wrote a memorandum, or rather a request to Mr. Symington, correct?
Correct.
That was in 2009, correct?
It should be, yeah.
And it was forwarded to Mr. Godan in March 2009, correct?
Correct.
And in that memorandum, you were requesting what I refer to as it is indicated in the judgment, you were requesting a package deal, for lack of a better word. In other words, that you should, quote unquote, retire, because we don't accept it as a retirement. Number one. Number two, that you should then be rehired immediately. And what was the third thing? That the SARS must pay for the money owed to the GEPF. That package, that's what you were requesting, correct?
Correct.
Right. Now, Mr. Godan was then told by Mr. Symington that that package was not a good idea if any element of it was not going to happen, you should withdraw the request, correct?
Correct. Well, I believe it was Mr. Symington who said to Mr. Godan, no, it's Mr. Symington who advised me that the three parts should go together, and if it wasn't agreed to, then I shouldn't proceed.
Yeah, okay. I don't think that's exactly how it happened, but that's nothing much turns on that. The point is that Mr. Symington's advice was that this scheme should only be can only be advised if it was going to go as a package deal. But if one element was missing, it should be withdrawn. In a nutshell.
Yes.
Yeah. And because you see, once again, the judges in your judgment said that I was wrong to refer to it as a package deal, but that's a story for another day. So what then happened is that Mr. Godan became a minister after the 2009 elections, correct?
Correct.
A few months after you had given him this request, correct?
Correct.
And Mr. Mahashula became the commissioner for SARS, correct?
Correct.
And then Mr. Mahashula wrote the request for your so-called retirement to the Minister of Finance, who happened to be Mr. Godan.
Yes.
Right? Correct?
Correct.
And Mr. Godan considered this carefully and approved your so-called retirement, correct?
Correct.
Again, nothing to do. Pardon?
Retirement from the pension fund.
No,
Just repeat that. I didn't get that. Just repeat that.
Sorry, Chair.
What I said is that I retired. My intention was to retire from the government pension fund.
Oh, I see.
Okay, thank you.
Okay, so why did you write to SARS? I don't I'm sorry.
Just pause, Advocate Mpofu, Honorable Karen.
Sorry, while you were asking for clarity, I couldn't hear what that third part of the retirement package was.
Oh, okay.
Some funds, can we just have that clarified as well?
Yes, thank you, Honorable
Just
Member.
repeat, Mr. Pillay again. In full.
Chair, I applied as part of that package to retire from the pension fund because I wanted to access my pension fund.
Sorry, just before that, Mr. Mpofu said that there were three components to the deal: retire, rehired immediately, and then SARS to pay something, and I couldn't hear what it was.
Yes. Yes. SARS to pay.
Advocate Mpofu or Mr. Pillay?
No, I can clarify it, Chair, if you don't mind.
Okay, please clarify it.
Thanks. Yes, Honorable Heron, this is very important. Yeah, it was what Mr. Pillay and I call a package. Yeah, had those two elements: retire, get the minister to agree for SARS to pay the penalty. There's a penalty if you retire before you reach the age 60. There's a penalty that is payable, and only with the approval of the minister that you fall under, in this case it would be Minister of Finance, can that approval be received for the employer to pay the penalty. So that was the second, or rather the third element, sorry. The second element, as I listed them, was that he would be rehired immediately. In other words, he would so-called retire, but be rehired immediately on a contract. Is that more or less it, Mr. Pillay?
Yes, it's on contract. Yes.
Yeah, thank you. All right. So, and just we'll come back to the sequence, but just so that Honorable Heron just has a complete picture. As it's actually happened, your so-called retirement happened at midnight on the 31st of December 2010, correct?
Correct.
And you were rehired.
Just a pause, Advocate Mpofu, Advocate Bauer.
Just as a sorry, Advocate Mpofu, I'm not interrupting you.
Okay,
It's
no
discussed
problem.
at paragraphs. It's discussed at paragraphs 124 onwards. This package of the judgment.
Yes. Well,
Okay, proceed, Advocate Mpofu. Thank you.
Thank you. Except the judgment didn't said it was not a package, or rather something like that. But that's fine. Yeah, that's true. What I was just saying, as a matter of fact, just to complete the picture for the honourable member and other members, the retirement, so-called, happened at midnight on the 31st of December, New Year's Eve, 31st December 2010, correct?
Correct.
Mr. Pillay?
Correct.
Yes. And you were rehired a minute later, 1 minute later, just as we were celebrating New Year's, 1 minute after 12 on New Year's Day, the 1st of January 2011, correct?
That's correct.
Thank you. Yeah, so that was the nature of the scheme. I call it a Ponzi scheme, yeah, but you might have a different word there.
Well, Chair, through the Chair, I should point out that all of these matters came before the courts, and the courts have applied themselves to it.
Yeah.
And
the court said it was okay.
The court said it was okay.
Yeah, I know. I was there. Yeah. Okay. But be that as it may, the committee will have to make its own mind on it. Yeah. Because you have raised it. I was saying it's not relevant. Yeah, but Ms. Bauer says it is. Yeah. So the scheme then, so effectively, the third element of the scheme is really what the public protector was worried about, namely that Minister Godan then approved that SARS must pay 1.1 million of the penalties to complete this scheme, correct?
Correct. I would prefer the package. It wasn't a scheme.
Yes, no, sorry. When I say scheme, I don't mean it negatively. Yeah, let's say package. Yeah, without that approval by Mr. Godan, the package would have fallen flat, correct?
I believe there were, yes, they would have fallen flat, and then there were other options which would have.
Well, okay. And you said at some stage, or rather, when you were rehired in the same position of Deputy SARS Commissioner, correct?
In the role of Deputy Commissioner.
SARS, yes.
Yeah. But I didn't have the same duties any longer that I had.
Yeah, but
prior.
you had the same title and the same money, correct?
Correct.
Yeah. And yet, you were, well, maybe let me ask you, because there are so many versions of this. What was the reason for you to be so lucky to get this package? By the way, do you know that there's no other South African human being has ever received such a package?
Chair, through you, I was told that 2,000 South Africans also accessed such. This matter has gone all the way, it's gone to the Constitutional Court, and the court has accepted that. The next thing I want to point out is that Commissioner Magashula pointed out, and I pointed out in my affidavit, that in the ordinary course of events over the next few years, SARS would have saved money, because SARS would no longer be contributing on a monthly basis to my pension. So that was submitted in an affidavit on the 21st of May, 2019. But of course, it was never responded to. And I don't think Mr. Magashula's affidavit in this respect was also responded to.
Yes. No. Okay. Be that as it may, I was asking you, what was the reason? Well, you say you don't know that. You think there are thousands of people who received a similar package? Yes.
We were told at the time when Commissioner Magashula discussed with the relevant public administration official that there were about 2,000 people who accessed
such a thing. Yes, actually, I think the number was 3,000. Yeah. It was said about 3,000, but it's a lie. There's no such thing. But anyway, we'll come to that. Yeah.
My reason.
So there were about sorry.
No, I was saying, Chair, Mr. Pillay was saying they were told at the time that there were about 2,000. I'm saying the actual number that they had was 3,000.
3,000.
Yes.
Okay.
But I was just saying that was just a phantom number. There's no other human being in this country who has ever received the package that Mr. Pillay, and I'll demonstrate it just now. Yeah. All right, Mr. Pillay, sorry. You in your affidavit, you cited 4 examples, not 3,000, correct? Including my old friend, Mr. Geert Stevens.
I cited 4 examples from within SARS.
From within SARS?
Within SARS, all of them within SARS, of people who retired and were rehired.
Yeah, you see, that's where the misrepresentation was. So those people were retired and rehired, correct?
Correct. 1 minute past midnight. Yes.
No, that's exactly the point. Some of them had to be recalled when there was a shortage, not they didn't retire and get rehired within 1 minute.
Well, I'm not sure about that.
Well, I'm sure.
I think
Okay, but if I'm right, then you'd understand that those examples, those 4 examples, should be thrown out of the window. In other words, it should not be comparing like for like.
well, I mean, what you're saying is that it would be okay if I pretended to be out of work for 3 months and then I was rehired.
Is that what you are accusing those people of doing?
No. That's what you're saying.
No. When did I say that? Maybe I forgot. I just, that's not what I'm saying. I'm saying those people were genuine, unlike you. They might have retired. Yes, you are right there. And then maybe 6 months later or a year later, SARS realizes that they might need their skills. They approach them and they negotiate a contract. Nothing wrong with that. I'm just saying none of them were the 1 minute specials like you. You are the only South African who has ever achieved such a feat.
Well,
and it probably will be for the next thousands of years. I don't think it will ever be allowed again, that kind of Ponzi scheme.
No, that's not a scheme. And Mr. Chair, I object to that. The matter has gone all the way to the Constitutional Court, and the public protector has failed to prove otherwise.
Okay, objection is noted. Thank you.
Okay, thank you. All right, sorry for the scheme. Yeah. No, you cited in your affidavit, operator, if you can bring it up, it's okay. I don't know what I think is, all I know is that it's paragraph 25.6 of Mr. Van Pillay, Mr. Pillay's affidavit.
25.6.
Yes, Chairperson.
Thank you.
Mr. Mpofu, can you tell us which affidavit?
The one he did in his case, or rather when he intervened in Mr. Godin's case, the one that we've been dealing with, case number 36099. All right, while they're looking for it, Mr. Pillay, to save time, the persons you referred to, one was Mr. Trevor van Heerden, correct?
Correct.
Who had retired at SARS with effect from 31st August 1999, correct?
Correct.
And later he was employed as a specialist in legal drafting, correct?
Correct.
No, certainly not a 1 minute special, correct? Correct?
I don't know what that means.
It means your situation where you were retired in 1 minute and were rehired the next minute or the next 2 seconds.
Chair, what I'm saying is that the intention, and it is explicit, was that I was retiring from the pension fund.
Or you're not retiring from SARS?
That was not the effect of it. But if one retired from the pension fund, then one retired from SARS, so one had to be rehired on contract. That is the rules.
I see. So it was a double retirement.
This was not a subterfuge. And by the way, this was well known in SARS. There was no attempt to keep any of this under wraps and to make it out to be a particular scheme. And I point out again that the matter has gone to court, has gone right to the Constitutional Court.
And the court says it's fine.
The court said, you have not provided evidence to them to make a different view. They took a view. They made a judgment on what was placed before them.
Yes, Mr. Pillay. So what are you doing here? You came here knowing that there was a judgment on the matter. You came here to assist this committee to deal with this matter, correct?
Correct.
Thank you. All right. So you agree that Mr. Van Heerden was not a 1 minute special like you?
No, I resent that. Chair, I'd ask for your intervention.
Okay, I'll rephrase. Okay, fine,
is being insulting, and I don't think you should be allowed to do that.
1 minute is an insult. Did you retire at...
Your intention is to insult me.
No, Mr. Pillay. You are
Advocate Mpofu. Advocate Mpofu,
yes.
You were just giving a suggestion of rephrasing that. You can achieve the same thing with the rephrasing without.
Yeah.
Thank you.
Mr. Pillay, you're the one who gives gratuitous insults according to the court, and that's why you were marked with attending client costs. But we'll come to that later. So, okay, let's go. I'm rephrasing. You agree that Mr. Van Heerden was, there was a period of more than 1 minute between him retiring and him being called back, correct?
I cannot remember that. You can tell me what was the period.
Is it possible that it was more than 1 minute?
I don't know.
All right. The next one was Mr. John Hansen. Remember him?
Yes, I remember Mr. Hansen.
He retired 31st December 1998 and was rehired 6 October 1999, almost a year later, not a minute later. Correct?
Correct. Chair, I think the Advocate Dali has made his point.
Yeah.
Whatever the point he wants to make.
No, fair enough. Okay, no, then we won't waste the time of the committee. The point I'm simply making is that the 4 examples, you even included Mr. Moyane, the 5 examples that you've given were not comparing like for like. And I think that's the point you're saying I've made, so we can move on, correct?
But Mr. Chair, is my affidavit here on trial? Is there an untruth that is there in that?
No, the untruth is what you've just told this committee, which is to say that these 4 people were comparable to your situation. No. So I'm trying to unpack that untruth.
No.
And the court said it was fine, but I'm saying the committee will make up its own mind. That's the only untruth we're dealing with for now.
No, it's just...
Pardon?
So Mr. Gert Stevens was rehired. Just go up to Mr. Gert Stevens.
Yeah.
Go to Mr. Gert Stevens again.
Yeah, 25.6.4, yeah. He was rehired on the 1st of April 2003, having retired on the 31st March. Yeah.
Yes, what is that?
It's a 1 minute special.
So so how am I unique?
Okay, that's fine. So you agree that the others don't, the only one that is like you is Mr. Geert Stevens?
No, Mr. Chair, I don't know from the thousands of people who work in public administration in South Africa how many similar cases there were. We were told there were about 3,000. We asked for the records. We could never get the records.
No,
so I cannot pronounce on whether I am unique or not. I made a request. I did not approve this request myself.
Yes. No,
Mr. Opa Magashula made a recommendation.
Yes. Mr.
took his time. He finally approved that, and that is where I stand on the matter.
Okay. No, let me assist you. I'll even be on your side. Look at Mr. Kosi Low. Him and Mr. Geert Stevens are the same. 31st December 2013, 1st January 2014. The other one is 31st March 2003, 1 April 2003. So let's eliminate the other two. Do you agree that in the case of these two persons, at least these are the only two persons who are comparable to you in terms of the 1 minute number, correct?
Chair, from what is presented here, and we don't know, these are just the examples within SARS. These people were re-employed on contract day after they retired from the pension fund.
Yes, like you.
This is what this says. It says nothing about anybody else in government.
No, no, Mr. Pillay. This is your affidavit, right?
Yeah.
Yeah, you're the one who did this. So, and I'm not saying that it's talking about, you said, in fairness to you, retired, then continued to work for SARS after retirement. So yes, I agree with you. This is just SARS, okay? Now I'm saying in these examples, you have two, but I'm saying to you, those two persons did not have their penalties paid by SARS, which is the real issue here. It's not so much that people retired. I'm agreeing with you. People might have retired, others might have been rehired, and as we have seen, some of them might have been even rehired immediately. But we're talking about the package here. Do you understand?
Mr. Chair, I understand that there is a package. I understand. I requested it was approved. I also understand that there was in this a saving to SARS over time.
That might well be, Mr. Pillay. I accept that. I'm saying there might be a saving. Well, no, I don't accept it. But for the purposes of my question, let's put that aside. That there might have been an eventual saving, but that saving would have been fortuitous, isn't it? It could have been a loss.
How is it going to be a loss?
Well, because they say, in pension law, there might be a saving that happens because the markets go a particular way or whatever. That's not what I'm not discussing that. We'll come to that if you want to. I'm simply saying that the scheme at that time, or rather the package, cost SARS and the taxpayer 1.1 million rand. Agreed?
Agree, and this arrangement saved SARS money over the next few years.
Okay, so, well, I'm sure that thousands of South Africans would like to save SARS by getting a 1.1 million rand windfall. We'll come to that. Let's do it step by step here. I would like to save SARS as well, if they can give me 1.1 million rand and a monthly pension payout on top of it. Yeah.
Yeah, this is badgering. I've answered the question.
Sorry, what did you say to me?
This is badgering.
I'm badgering you.
Yes.
How did I do that?
You're on the same thing over and over. I say, yes, there is a package. Yes, the penalty was paid. Yes, I retired from the pension fund. Yes, I was rehired on the day after. I say, I didn't approve these things for myself. Right. You want to say it's a scheme? You say it's a scheme?
No, if I said that, I apologize. No, I'm not saying that.
That's fine, Mr. Pillay. That's fine, Mr. Pillay. Can we now proceed, Advocate Mpofu?
Okay. No, Mr. Pillay, yeah, I'm not badgering you, sir. I'm busy trying to cross-examine you. You volunteered to come here. I'm simply saying that I have to, it's my job, sir, to demonstrate that your evidence and your motives for coming here are not as holy as you want us to believe. That's just what I do. Yeah. So that's really my only intention. And I only asked you once about this issue of the 1.1 million. I don't know why you're saying I've kept on answering it. Maybe you are imagining it.
Mr. Chair, we've been on this for about 20 minutes.
On the 1.1 million?
On the package. We've been on it for about 20 minutes.
Yeah, no, don't worry. We are on this. Yeah, you gave us a 500-page affidavit, Mr.
Yes.
No, Mr. Pillay, I think we have a set time for the process, so allow Advocate Mpofu to proceed with his time, because I think we'll be 30 minutes away from the time I set in the morning. Thank you.
Well, very far from that. Anyway,
I'm saying at the time I set as a chair, which is 4
I see.
o'clock.
No, you did say we'll discuss.
Thank you. Thank you.
I apologize, Chairperson. It's a Friday, you know. It looks like everyone is tired, including Mr. Pillay. But just be patient with us, Mr. Pillay. Okay, let's round it off. And in fact, in fairness to you, you tried earlier to say, the point is made, yeah. But then you said I must go look at Herr Stevens. You're the one who brought us back here.
No, because when you first put this, you said that I was unique.
Yes, but I was going through them one by one. You stopped me.
No, you stressed that the 1 minute after. You stressed this. You called me a 1 minute special.
All right, Mr. Pillay.
Don't be untruthful.
Okay, Mr. Pillay. No, I'm not being untruthful. I've just demonstrated to you that you are unique because you are the only person who has all the 3 elements of the package. Do you understand that?
You say so. I haven't seen.
Okay. Do you know anyone else? All right. No. My baby.
But you're not an authority on public administration.
How do you know that? How do you know that I'm not an authority on public administration? Who told you that? Do you just look at me and you know that I'm not an authority?
No, but all right. Then that means you've done the survey, you've checked all of this, and then if you tell me that this is unique, then I'll have to accept it because you're the authority.
Yes. No, Mr. Pillay, let's come down. I'm using your examples. You brought 4 names, correct?
Correct.
Yes. Now, it's not me, it's you. Now, I was saying, let's look at those names. And my intention is very simple. It is to support what I put to you up front, which is that there might be someone who retired, there might be someone who was rehired, there might be someone who, all these things, but I'm saying you, Mr. Ivan Pillay, are the only human being I know who had the package as defined. If there is someone else you know other than these four, then you can tell us. Do you accept that?
Mr. Chair, I don't know, but my expectation is that since it is allowed for in the law, and by the way, because of where we come from, there's no way I'm going to know, by the way, what is allowed for in the pension laws and in SARS laws. I asked to ask people, and people tell me. My assumption is that you can get, under certain conditions, the penalty paid, because this is what I was told. I'm not a person who sits and reads the laws and finds a loophole in the legislation. That's not my job.
No, Mr. Pillay, I think you are being unfair on yourself now. This is what, you don't have to read the law books. Mr. Symington said this to you, that this thing, package, can only work if all the three elements are in. If one of them falls away, you must withdraw it. It was a simple 2-page memorandum. You don't need to read any law books. And this was explained to you after you had made the application. Am I correct?
Chair, my question is this. How would I even know that a penalty would be paid for me? Can be paid for me under certain circumstances?
Because you asked for it, Mr.
No, what I'm explaining is that it was my intention to go from the pension fund and to pay the penalty. Then I was told that, look, in certain circumstances, the penalty can be paid by SARS. Okay. I made the application. None of these things in law was designed by us. It's there, and I must finally point out is that I don't authorize I don't approve of this thing myself. I made a submission, and it was for Commissioner Magashula to say no, for the minister to say no. I would then reconsider what I'm going to do.
Yeah, but the point I'm making, the minister is not going to say no. He's your friend and comrade.
No.
And he's the one who originated this thing when he was a commissioner of SARS.
No, that is unfair. That's a slur on the minister. It's just, yeah, you're just throwing everything around now and hoping something sticks.
Mr. Pillay?
Yes.
Advocate Bauer?
You like insulting people, Mr. Pillay.
Advocate Bauer?
Mr. Chair, I want to bring to your attention that it's quite clear from the judgment that the payment of the 1.258 million came into effect by operation of law. It's not a factual question. And the reference to the judgment is 214 and 215.
No,
Thank you for the clarity.
Well, it's not clarity. That's
proceed,
not true.
Proceed, Advocate Mpofu, with your cross-examination.
Yeah, okay, let maybe Mr. Pillay will help us. Mr. Pillay, you accept that the payment of the 1.1 million would not have happened without the approval of Mr. Godin?
My understanding is that once the early retirement was accepted, the issue of the penalties kick in.
No, Mr. Pillay, please answer the question. Do you accept that the payment of the 1.1 million rand penalty would not have occurred without the permission of Mr. Godin?
In the end, he approved it.
Mr. Pillay, this is the last time.
Yes.
Do you accept or do you reject the fact that the payment of the 1.1 million rand by SARS would not have occurred without the permission of Mr. Godin?
My understanding is that Mr. Godin okayed my early retirement and there was an automatic consequence. And indeed, he approved it.
You don't want to answer my question. That's fine. That's fine, Mr. There's nothing I can do. Yeah. Do you accept that when the package was presented to Mr. Godan, it was on the basis of the tripartite package deal that you would be rehired, the SARS would pay the penalty, and you would quote unquote retire?
Yes.
Yes, and that's the uniqueness of the package. And did you say when you were applying for this that you were okay? No. Before let's come to let's kill this quickly now. You said that you were proposing to serve SARS in a different capacity, correct?
Correct.
But it turned out that you were rehired still as Deputy SARS Commissioner, correct?
No, the title that I had was the same. My role was different.
Yeah, Mr. Pillay.
I now headed the risk and enabling of SARS. Enforcement was moved out of me to Mr. Jean Ravel. So 3,000 people went to Mr. Jean Ravel.
All right, but you were still the Deputy SARS Commissioner, correct?
Yes, I was originally one of three, and the title remained with me. Eventually, I was the only one left.
So that was in the same capacity then. Your capacity was Deputy SARS Commissioner, correct?
Yes, it's the title. There was no particular authority that the Deputy Commissioner had.
No, I'm not talking about authorities, Mr. Pillay. You're going to say I'm badgering you, but you're just refusing to answer my question. Well, when you were rehired a minute after midnight on December 31, 2010, you retained the position of Deputy SARS. They say you were rehired in the same capacity, right?
In the same title, yes.
Pardon?
With the title Deputy Commissioner, whether I really don't understand in the same capacity, because the core of my work changed to enablement from enforcement operations to enable.
No, capacity is not my word, Mr. Pillay, it's yours. You said, I'm reading from a memorandum you wrote, on 27/11/2009, Dear OPA. And then you say, the purpose of the memorandum is to explain that I have decided to take early retirement, as well as to recommend the possible approval by the Minister of matters that flow from my decision. Then somewhere you said I was expected to perform at a high level. This exacted this toll from me in the sense of my health and so on. And then you say that should you favorably consider my proposal to serve SARS in a different capacity, so it's your word, such service will have to be subject that I be appointed as a contract employee. This will allow me more flexibility. The second condition will be that my early retirement is approved in terms of the provisions of Section 6A, meaning that the Minister, in terms of the provisions of the above mentioned, shall approve the penalty imposed on my pension and so on. The GPF has indicated that the penalty amount my personal benefit to employer has to pay on my behalf is 1.2 million rand. That was the package. You proposed it on the basis that you should be in the same capacity, correct? Sorry, that's page 70, rather page 470, bundle E, item 1.1. Sorry, Chairperson.
I thought what you read was said it's in a different capacity.
Yes, That's, yes, you said in a different capacity, but I'm busy debating with you that you were then employed in the same capacity.
No, Chair, there is no, you look anywhere at the SARS, there's no special delegation for a deputy commissioner. There's no special salary band for a deputy commissioner. It is just a title. From the time that it was set up, it was never developed into anything. It's just a title. That's all. What really matters is what one did.
What are you saying? Are you saying that when you said to serve in a different capacity, you meant still as a deputy SARS commissioner?
No, I didn't mean that.
So what did you mean?
This is, so in other words, the commissioner could have said, listen, then you got to leave the title. I wasn't concerned about that. I was concerned that I wanted to move away from enforcement operations to the enabling space, which, by the way, is a recommendation that was made by our consultants, that I should eventually move out of the operations space to the enablement space.
Okay, thanks. I don't think you even know what you're saying yourself, but it's clear that you were, you said the work was stressful, it was affecting your health, and you would be prepared to serve in a different capacity. I mean, it's obvious. I don't know why you're running away from this.
That's what I said. I'm agreeing with you.
Oh, thank you. Sorry, it's my mistake.
I'm agreeing with you. I'm saying pay no attention to the title of Deputy Commissioner.
Anyway, what was the reason for you to get this win for this package? Or rather, to ask for it?
Oh, I had personal reasons to access my pension fund.
Yeah, but what were they?
They are personal reasons. They are medical and they are family related.
Okay, so at least in this memorandum, you said it was your health, correct?
Yeah, it's personal. Yeah.
And then at some stage it changed to something else, correct?
Yes, that's family. That's I think at some stage I spoke also about education.
Yes, it kept on changing many times, but yes. So what was the real reason?
No, the broad overall description would be it's personal. It took toll on my health. It took a toll on the health of my family, and it as a family as a whole, we were making out decisions about how to move forward. So the
Mr.
reasons
Pillay,
are personal.
yes, thank you. Are you okay? Are you all right? You sound, you're slurring now. Are you just tired? Do you want us to take a short break?
No, I'm fine.
You're fine. Okay, we can get on. No problem. No, I'm asking seriously. We can take a short break.
No.
Please proceed, Advocate Mpofu and Mr. Pillay.
We are going up to 4 o'clock. So
no, we're not going to. We're going.
Please proceed.
Yeah.
Please
all right.
proceed.
So
There are time.
okay. So you no, Chair. I have to. If I feel that the witness is.
He is fine. He doesn't want to take a break.
Yeah. Well,
Please
you are
proceed.
not. Yeah. No, Chairperson, you are not him. If he's not feeling well.
I'm the chairperson of this session.
Yeah, but it's my duty
He will say
tell
so
a
if he
witness.
needs it. Please proceed.
No, it's my professional duty if a witness is tired to ask him if he's all right,
There's a
whether you like it or not.
chairperson who is presiding over this session. It is not you.
Yeah,
Please.
you're not a doctor.
Please
Okay.
proceed.
Thank you, Chairperson. All right. So, Mr. Pillay, if we go to, you know that Mr. Nick Coetzee
yes,
said, Mr. Nick Coetzee said that this scheme, sorry, Mr. Pillay, that this package was not kosher, not all right.
I believe at the time, I didn't know that, but I believe he communicated with the commissioner and he pointed out certain things to the commissioner. He also later communicated with the minister to say there's nothing unlawful about it. So
Yeah.
he had some misgivings about it.
Yes.
And he raised the question that if somebody else asked for such a thing, would you give it to them?
Yeah. No. Okay. So let's go to.
But I only saw that afterwards.
No, fair enough. Yeah, in the court papers. Yeah. So let's go to bundle E, page 468, please. This is Mr. Kutsia saying that okay, please just work with me, operator. Yeah, I'm resending this email on account of a slight change I've made to the two attached documents. The changes indicate that the reason why Mr. Pillay is requesting approval for early retirement is to provide for his children's education. This was one of the versions of your request here. And not, as I have previously stated, that he wished to pursue other interests. You will now have to consider to recommend, and the minister considered to approve if this is sufficient reason. And you see that he puts that in block letters. In other words, the reason was important, okay? To recommend or approve Mr. Pillay's application for early retirement. If his application is duly approved, it could technically be construed that SARS is willing to contribute from its budget an amount of 340,000 towards the education of his children, right? Says, yeah, I admit this is a rather cynical viewpoint, but it can be a viewpoint that may be held by other parties as well, that may put yourself and the minister in a tight spot. You see that?
Yes.
Especially because Mr. Pillay was reappointed in his present position. The argument may be that he was able to continue with his present functions, but his early retirement and reappointment was purely to assist him to be able to provide for his children's education with 340,000 contribution, in quotes, from SARS. In other words, this whole package, as you call it, was just a free bursary for your children at the taxpayer's expense, according to Mr. Kutsia's analysis in this email, correct? Or rather could be viewed like that.
It could be, but there are also other views. Flock Symington had another view. David Makapela, SARS attorneys hired by the then Commissioner Tom Moyane, also said that the arrangement, the request and the approval was lawful. And again, I point out that all of these things went through all the court's processes right up to Constitutional Court.
Yes, but Mr. Flock Symington did not say that. It's a lie to say Mr. Flock Symington. Mr. Flock Symington only said, and the court found that you and Mr. Godan were misrepresenting what Mr. Flock Symington said. He only said...
The court didn't find that.
All right, I'll take you there. But the so-called, remember Mr. Godan said that he before he approved this, he took the advice of 6 people, including Mr. Symington, correct? Remember that?
Yes, I think I remember.
Yeah. So the court rejected that.
My understanding is what the court rejected is that these consultations had any bearing on the
decision.
lawfulness of the action. In other words,
Yeah.
showing that you've consulted A, B, C, D, E.
Yes, in other words, sorry, Mr. Pillay, finish.
No, I finished. I think I've
Okay.
made my point.
Yes, in other words, what the court said is that what you and Mr. Godan wanted the court to believe, that you had consulted so-called experts, was false.
No, but you see here that OPA consulted with Nick. Is that false?
Nick who?
The same Nick Kutsia that you were talking about.
No, Nick Kutsia was not even one of the 6. I just want to make sure. No, this is what this is what you and Mr. Godan said. The consultation with the so-called expert was said to have advised Mr. Godan. Much cannot be really said about them if considered in the light of the argument by the public protector that the consultation process Mr. Godan seeks to rely on does not assist his case. Sorry, I can go to the judgment at paragraph 169, sorry. While you are waiting for that, Mr.
Paragraph 169, what page?
I don't know.
Now, how do we go there?
The same way we went there before, when we went to paragraph 95.
Sorry?
The same way we went there when we went to paragraph 95 just now.
Well, there was a page, sorry, we had a page then. Did you get it?
Thank you. All right, 169, thank you. Of the retirement judgment, the Pillay judgment, not the rogue unit. Yes. Remember, you and Mr. Godan wanted the court to believe that this was a very well considered decision. Even 6 experts and so on were consulted, and it was not some broodskap thing. It was really like arm's length. But the court said this. Much cannot be really said about them if considered in light of the argument by the public protector that the consultation process Minister Godan seeks to rely on does not assist his case. Minister Godan's submission that he consulted with the best available experts with extensive experience in the retirement and pension environment when considered against the here under arguments of the public protector is not sustainable. Right? 1. Firstly, the consultation with Mr. Symington took place some 17 months before Mr. Godan considered Mr. Pillay's request for early retirement. This is what the public protector pointed out. This public protector who must be impeached. She saw through that particular lie because you couldn't rely on something that happened 17 months before. So there is no indication that on record that Minister Godan consulted with Mr. Symington after I received Mr. Mahashule's memorandum. So that was the line number 1 from you and Mr. Godan. Then,
No. Don't. I didn't lie. Don't say I've lied about anything. I haven't lied about anything.
Okay. Did you say in your affidavit at paragraph 10, no, actually 12, I associate myself fully with the detailed submissions of fact and law set up by Minister Godan in paragraphs 9 to 71 of his founding affidavit. Did you say that? Did you sign that?
Yes, I associate myself with that.
Yes.
But I was not there at the consultations to tell you what happened to it and when. I didn't lie about anything.
Yes, Mr. Pillay. But if you associated yourself fully, as you say, with this, and it turns out to be a lie, then you must suffer the consequences, I'm afraid.
No, but
Okay.
the consequences are that the judgment said in the end that that arrangement was lawful. And your client failed to make her case. That's what the judgment said, and that stands.
Yeah. No, it didn't say it was lawful. Okay, I don't want to go legal. Do you know what a judicial review is? Do you know what is the difference between a review and an appeal, for example?
No, explain to me.
Nah, some other time, Mr. Pillay. So, okay, so the second lie was this. I'm now at 169.2. Please, let's go back to the judgment. The court then says, secondly, Mr. Magashula cannot be taken as an expert for the purposes of advice to Mr. Godan, or rather, of the advice Mr. Godan was looking for. Mr. Magashula concedes as much in his affidavit to the public protector that he is not a lawyer and was acutely aware of the prescripts pertaining to the employee retirement. Thirdly, there is nothing presented to this court evidence when Mr. Donaldson, that was the other so-called expert, was consulted or what his advice was. And then they quote a case that we presented to the court about that legal advice must be presented on paper. So similarly in this case, where it's motion proceedings, it was incumbent upon Mr. Godan to set out exactly what advice he required and so on. As a result, we do not know the remit of their discussion. Next one, the other expert, so-called. Nothing contained in Mrs. Hendricks' affidavit amounts to independent legal advice by her or any other person relied on. So, next one. Fifthly, Mr. Godan never had any direct contact with Mr. Govender. He also claimed to have consulted Mr. Govender falsely. That was also a lie. Fortunately, Mr. Govender gave an affidavit to the public protector and said he never spoke to Mr. Godan, and to the extent that he spoke to Mr. Magashula, no mention of a Mr. Pillay was ever mentioned to him. Anyway, why are you laughing? Is it funny?
Yes, because Mr. Chair, I must point out that it is not a lie to say that Mr. Godan spoke to so-and-so, but that the judges believe that that person that Mr. Godan is relying on, that advice is not of value for what the judges require. That doesn't make it a lie.
I agree. But when he says he relies on Mr. Govender that he has never had any direct contact with, as the judges say, is that the truth?
On that matter, I think when you get an opportunity, you must ask Mr. Godan. But what I know is that both Mr. Godan and Mr. Magashula at different times spoke to Mr. Govender. I spoke to Mr. Govender myself, not in any detail, and he said he is talking to Mr. Magashula.
Yes, but in his affidavit, Mr. Pillay, we're hearing that for the first time. In his affidavit, he says, yes, he had a discussion with Mr. Magashula, but the name Pillay was never mentioned. He was asked about some broad principles about voluntary severance packages. That's fine. That's if you think that's the truth, that's your baby, between you and your God. Okay, the lastly, it says at 169.6. Lastly, in the conversation with Mr. Godan had with Mr. Oliver, that was supposed to be the last so-called expert, what we're privy of to is that they were discussing, among others, the importance of retaining the services of Mr. Pillay. Except for the retention of Mr. Pillay at SARS, this conversation would not have assisted Mr. Godan about the early retirement of Mr. Pillay. So the court debunked any reliance on the so-called experts that you and Mr. Godan relied on.
With your permission, can they read 170 also?
170. Yeah, well, I can. Having said that, it must be nevertheless borne in mind that Mr. Mahashula's memorandum is a submission made to Mr. Godan by Mr. Mahashula as the Commissioner of SARS. It is not merely Mr. Pillay's application directly to Mr. Godan. Mr. Pillay applied to Mr. Mahashula, and this memorandum to Minister Godan was Mr. Mahashula submitting a memorandum to him, which he, Mr. Mahashula, asked and recommended for the approval sought by Mr. Pillay to be granted. So Mr. Pillay's application came to Minister Godan with the endorsement and recommendation of Mr. Mahashula as the commissioner. The ultimate employer responsible for the administration of SARS. Can be said that Mr. Pillay's application came to Mr. Godan with high recommendation and commendation. Yeah, that's why Mr. Mahashula was in the scheme. So how does that happen?
No, I think that's being very unfair to Mr. Mahashula.
Yeah, but that's why he was a respondent.
No, but you and again, there your client was unfair to Mr. Mahashula.
Yes, maybe that is so, Mr. Pillay. That's not what we're debating now. You asked me to read this paragraph. I'm telling you that all this paragraph does is to show that this was the Ponzi scheme had many members.
No, again, you're just smearing. You're trying to just throw your smears around.
Yes, yeah. What are you going to do about it?
Well, it won't help you.
Yeah. All right. So I'm saying, Mr. Pillay.
Advocate Mpofu.
Yeah.
Advocate Mpofu. We now, the time now is 4 o'clock.
Yes,
and that's the time that I indicated to you 9 o'clock this morning. Yes, that we will end your cross-examination at 4.
Yes,
we are at that time now. I would like you to wrap up, please.
No, Chairperson, I can't. There's still a lot of material, but I'll try, Chairperson. But as I indicated in the morning, there's still.
I will give you the next 10 minutes to wrap up. Thank you.
No, I'm not going to finish in 10 minutes. There's a lot of evidence.
I will be finished with cross-examination at 4:10. So I'm allowing you to wrap up.
Hello, Chairperson, please listen to me. I'm saying to you that you might have in the morning thought about 4 o'clock. I didn't know that it's going to take me 10 questions to get one answer. Neither did you, by the way. So I know that
I am indicating that
you must take into account
your session at 4:10, Advocate Mpofu. Thank you.
It's fine. You'll stop me if you want to, but I'm not in control of how the witness answers. You know that. So you're just being unfair again, Chairperson. So let's, Mr. Pillay.
Yes.
Yes, we were at the point at which you had confirmed, at least, that, or rather, you asked me to read a paragraph. I wouldn't have read it if I knew that I was going to be curtailed like this. But now that I've made that mistake, I'm saying all this shows is that Mr. Mahashula, who wrote the letter to Mr. Godan, was part of the scheme.
Well, I just hope
you were still busy saying my client was unfair on Mr. Mahashula and so on. I'm saying to you that what happened, Mr. Pillay, and you know it, is that Mr. Mahashula wrote to Mr. Godan as if he was not part of this when he was the Commissioner of SARS. Dear Minister, Mr. Pillay wants to retire. Can you also approve his contract that he must work here immediately and so on? The entire package. And of course, Mr. Godan signed it and said it's approved. But the things I'm putting to you are this, Mr. Pillay. One, this was an unprecedented move. it was costly to the taxpayer. It was motivated only by the fact that actually Mr. Godan should have recused himself from this, knowing that it had come. Basically, it was what in corruption language we call the javelin, where he, as commissioner of SARS, is now receiving his own request, so to speak, as minister later and approving it. That's just it's not done. But
what is the question, Mr. Chair? What is the question?
Listen, cool down. Let me put the proposition.
I'm not angry. I'm just asking what is the question.
It's coming. Relax.
Yeah.
Okay? Take a deep breath and relax. The question will come. I'm putting to you that proposition that because of the fraudulent scheme and the corrupt and unethical...
Chair, I object to that.
But I thought you wanted me to finish.
No, I want you to finish, and I actually want you to finish right now. You can't just throw things around like that, and which you can't prove, which has gone to court, and which in court you failed to make the case.
Okay.
Thank you, Mr. Pillay. Advocate Mpofu, the witness is raising an objection.
Well, I've never heard of such a thing, a witness raising an objection. But yeah,
you are hearing
I've seen things here, yeah.
You are hearing it now.
Yes, that's what I'm saying.
That's it.
Congratulations to me. Yeah.
That's it.
Yeah. Now, Chairperson, please, why are you harassing me?
Ask him. You're not being
What do you
harassed.
mean when
Please
you say that's
proceed
it?
with the few minutes that is left, conclude your work. You're not being harassed.
No, you are harassing me.
Indicating
What
to
do you
you
mean
that
that's
the
it?
witness is uncomfortable with you, with the issues that you repeatedly are saying to him, and he's raising an objection. And as a chair, I am noting and accepting that, and I'm referring to you to refrain from that.
Yeah, but don't say that's it to me. I'm not your little boy. So
You must
okay.
refrain from that.
Thank you. Okay. Thank you. Mr. Pillay, the reason why, please forgive me, the reason why I was packaging these things in a long series is because apparently I'm going to be stopped in the next few minutes. So that's the only reason. Otherwise, normally I would break it down into small questions. Okay, let me put it this way. What we're going to argue at the end around these issues that I've canvassed with you so far, before I get rudely stopped, is that firstly, you are aware that there were so many bases on which the public protector independently relied for the conclusion that the rogue unit was rogue. What is your comment?
The public protector did not make any independent check on any of those allegations. She swallowed them hook, line, and sinker, and that's not what a public protector should do. So that is not an excuse. In fact, that says a lot about her and how she does her work.
Yeah, no, save us the editorial, Mr. Pillay. Did she not give you an opportunity in terms of Section 7.9 to comment?
She did, but she paid no attention to it. And that's what the judgment found. She did not grapple with the evidence at all.
Did she not give Mr. Godan an opportunity in terms of Section 7.9?
The public protector goes through the motion. She does not she does not do those things in the required spirit. She doesn't deal with the evidence. The judgments go into some detail with that. She doesn't assess it. And on the other hand, when it comes to the allegations, she accepts it in total.
Do you know that she's well, you should know because you were there, that she worked with investigators who did all this background work that you are talking about.
You okay? You're informing me, yes?
No, I'm not informing you. I'm asking you, when you were there, did you see other people? Maybe they didn't call them investigators, but did you see them?
Yes, I did see them.
Yes. So you think all those people were just going through the motions? Why? Because what? They hate you.
No. I think that's not the issue. We know that these matters can be investigated, and I think, by the way, it is the public protector has got to explain why she didn't do these things. I don't have to give you a supposition on why she didn't do that.
Yes. Okay, that's the first proposition. The second proposition is that you, as the mastermind or the boss or whatever of the so-called rogue unit, were aware that that rogue unit was committing crimes, including treason, such as spying on the NPA.
I'll say again, the foundation of the unit was lawful. Insofar as its activities are concerned, the public protector didn't examine its activities. She didn't interview a single person from the unit. And in fact, on the equipment, which she was insisting it must be there because it's not there, she did not interview anybody on all of those things. There are no affidavits.
Yes.
And that is the point. And until these things are gone into, they remain mere allegations. And
Yes.
I deny that I was involved in unlawful activity.
Right. And I also will argue that from the evidence that you've given, it becomes clear that the only reason that you were elevated to such heights to Deputy SARS Commissioner was not because you are some particular whiz kid, but because of your kinship, comradeship, friendship, whatever you call it, with Mr. Godan.
That's absolutely not true.
Okay.
If you know Mr. Godan, you will know that it's not true. He's not a person who acts in that way. As far as I know, he's hardest on the people that he has some.
What are his friends? Yeah.
No,
Okay.
and I dispute that I'm his friend. It's not true.
Really? Okay.
Yeah, that's not true.
Then, yeah. I also put to you that the package that you and Mr. Godan, the unique package that you and him devised, at which he played for both sides as SARS and the Treasury, was a contrived scheme to rob the taxpayer of money and to give you free education on behalf of your children. And by the way, I know you deny that, but let me just, because we don't have time, but just point out what the 5 versions that you were put up for why you entered into the package. You'll find that at page 979, item 1.1, bundle E, Chairperson. And
Thank you, Advocate Mpofu. That's your last take.
Well, are you stopping me in the middle of a sentence?
No, when we conclude that, it will be the last take.
No, Chair. Okay, let me conclude this, then we'll talk, because otherwise I'll be wasting more of your time. This is what is said there, Mr. Pillay. Are they trying to find it? Okay, I'll read it to save time, Mr. Pillay.
Yeah.
It says that these are the versions given at different stages. The first one was wanting to fund the education of your children, as indicated in your initial memorandum of 25 August 2009. which you will find at page 39 of your application. The second version was to pursue, quote, other interests, as stated in 8th of October 2009 by Mr. Nick Kutsier, that you and I have discussed. You understand that?
Yes.
The third one is health reasons and wanting to serve in a different and less exhausting capacity, as indicated in your memorandum of 27 November 2009. That's the one we went through. You remember that?
Yes.
The fourth one was for personal reasons. That's the one you also said here, as indicated in the application for approval letter to Minister Godan on the 12th of August. Remember that?
Yes.
That's the letter of Mr. Mahashula to Mr. Godan. And then the fifth one was you needed to follow your wife and children to Holland, as stated by Mr. Mahashula in his affidavit to the public protector on 20th March 2019. You remember that version?
Well, that you say is Mr. Mahashula. That's what.
Yeah, but he got it from you. How did he know your children were in Holland?
Well, half my family did move to Holland. Yes.
It's when you moved. Are you in Holland now?
Yeah.
Okay. Are you enjoying your retirement?
Not really.
Oh.
Not really, because
Okay. Yeah.
because the state capturers are still in pursuance.
Yes. And do you still get paid in respect of this retirement, so-called?
Yes.
Yes. And on that basis, then why did you go to court and want to escape on a technicality that, which you did? The court agreed with you, granted, that the matter is more than 2 years old, and therefore the public protector had no jurisdiction, which is what was found. When even today you are continuing to get the money, how can that be in the past when you are continuing to
No,
the money of the South African taxpayers?
That's a terrible.
Now, let me finish, Mr. Pillay. Yeah, how can that be something? Why did you and Mr. Godan have to hide behind that technicality, albeit that the court agreed with you?
Okay, so I'm hearing the words of a frustrated man. Again, who's just he's just throwing insults around.
I am frustrated. So, I'm being gagged.
Yeah. No. It's because all day you've been at this thing, and
you volunteered to come here, Mr. Pillay.
No, I volunteered.
You won't be here all day.
No. You must remember that the pension, I contribute to a pension, and the employer contributes to a pension.
Yeah.
And remember, I said that SARS has a saving. Mr. Magashula said SARS will have a saving also. Mm-hmm. I deny that this is a scheme. And the very fact that you can find all of these things, all of these documents show there was no scheme in hiding all of these things. Everybody knew that I took this early retirement. So there's no attempt to hide any of these things. And I must point out again, you came with all of these things to court, and at every level in court. And as you point out, there were some arguments we lost, and there's some arguments you won, but overall, your client didn't make the case. And that is the issue.
And therefore, what? Should we stop the inquiry then? Because the client.
Thank you. Thank you, Mr. Pillay. Thank you, Advocate Mpofu.
Chairperson, for the record, Thank you. Yeah. Okay, for the record, I'm not finished with the cross-examination.
Thank you, Advocate Mpofu, and you're well aware, together with evidence leaders, as I indicated in the morning, but further than that, the witness is available for today and not available at any other time. So I'm going to take a 10-minute break. We'll
is
break
that forever,
after 10 minutes.
When you say at any other time, you mean forever? Amen.
I did not say that.
I'm asking.
Thank you, and we'll be back after 10 minutes, and I will invite the members to engage with Mr. Pillay. Thank you. We'll
Thank
pause
you.
for 10 minutes.
Thank you. See you later, Mr. Pillay.
Recording stopped.
And I'll tell you from my experience in SARS, that SARS has 15,000 staff at one stage. And the enforcement wing had about 3,000 people. So we literally did thousands of audits and investigations. The first issue, and there are separate issues, the first issue is how to deal with complaints. That is, or how to deal with complaints and allegations. So there has got to be a sifting process, filtering process. So you put it through certain filters. These are not intensive investigations. These are what I would call light investigations. And it's like I said in my evidence. It's, for example, it would be, is this an anonymous complaint? And you should be clear, are you accepting anonymous complaints or not? Secondly, the complaint or the allegation, is it specific enough? Or is it very general? So by asking, and then, can we get this in the form of an affidavit? Because that gives you also another filter. If people are not prepared to make affidavits, it might indicate that it is frivolous. So there are a number of things one should do, which is an in-depth investigation to try and sort the big funnel that of complaints or allegations that you get. And it would include, in my view, that if somebody else has done a report or claims to have done an investigation or there's an inquiry, it would include understanding who did the inquiry, what were the terms of reference, was what is done properly according to the mandate, were people given the opportunity, apply the ODI rule, and is the evidence comprised of sworn affidavits? So that's the part where when you're dealing with the allegations and complaints, you have to do that. Because in the case of the IGI report, any reading of that would say, these are the terms of reference, but why do you end up investigating SARS? When what you're supposed to be investigating is a rogue unit in the SSA. That would come. And then you would ask, all right, you're implicating Mr. Gordon, Mr. Pillay, and so and so. Where are their responses to these things? So without going deep into it, you would ask those questions. By the way, you would ask the same questions about Skakani report. You won't go into absolute detail about it. It's about how was this made, who did it, who was interviewed, what's the terms of reference. And when you see things like the terms of reference change, you know the warning bells should be ringing. So, and there's an element in this of operations management of a large number of cases. Because you can't do everything. You have a limited amount of resources, and the capability of your resources vary. So you want to have the filtering to be done well, and then you want to allocate the right cases to the right capability so that you can match complexity with skill. It's doable. It will take a bit of time, maybe 3-4 years, and you get better at it. So I hope I've answered the first question. Then, Honorable Chair, the second question, I think, is a general question about accessing the pension funds. In my case, I should point out that I was, I think when I accessed the pension fund, I was about 57 or 58. And the regulations allow, I think, to access the pensions funds from about 55. So people are allowed from about 55 to access the pension fund. The issue here then is not accessing the pension fund. It is that, and there are two issues. The one is that it's automatic if an employer agrees on the retirement from the fund, that the employer becomes liable for the penalty. I think that was the issue. And then the third issue was the rehiring. And generally, what they say is the rehiring should not be on exactly the same conditions. And I'm saying, and the commissioner said, my job changed, and it changed from operations, it was a highly pressurized job, to enablement. Thank you, Chair. I hope I've answered.
Thank you very much, Mr. Pillay. Thank you, Mr. Hendricks. I now recognize Honorable Nadada.
Thank you so much, Chair. Chair, before I go on, am I audible, Chair?
You very audible.
Thank you so much. Mr. Pillay, good afternoon.
Good afternoon.
Can I please ask my questions individually, then you respond, and then I might have follow-ups based on those responses. Mr. Pillay, can I just understand, based on your affidavit, you've mentioned that the core of your affidavit is that you've been found guilty by reports of the PP, namely 3 reports on the SARS intelligence unit around your pension, and 1 report being currently under review. Would that be my correct understanding of your affidavit, or could you clarify that?
Yes, that's the scope of the affidavit.
Cool. All right. And then you indicate that in 2 of the 3 reports, you were ignored or irrationally dismissed. Is that correct?
Yes. In all 3. In fact, the 3rd report, I wasn't told anything, and she's published findings. So I knew nothing. I read it in the newspaper that there's a finding against me. So in the 3 reports, what we are saying is that when in the first 2, I did get the notices, we respond, but she pays no attention to the evidence. In the 3rd one, I wasn't even asked for anything.
All right. So let's jump into some of the detail that I would like to understand, Mr. Pillay.
Yes.
In the pension or retirement matter, it was indicated in one of the reports that you benefited fraudulently.
Yes.
And you then, obviously the court ruled and made findings on that, and I won't go into details. But you then indicate that there were many errors that have taken place in getting to the conclusion of this report. Do you mind sharing with us what those errors are that she managed to draw conclusions on this particular issue? The reason why I ask this question is because in the previous, one of the witnesses that came to give evidence to the committee had indicated errors, Mr. van Lochenberg to be specific, and there was a written question that was given to the PP, and she was not aware of any errors, according to her. And obviously, we're busy compiling a list to check whether she is aware of the errors that are alleged in that particular testimony. So I want to check with you, what are the errors, particularly on the retirement or pension report that she had made and drew conclusions on?
So, well, one of them is that we had advice from Flock Symington, Mr. Flock Symington, who within SARS is an expert on the pension funds. And this matter of my pension has done the rounds with the NPA, and the fact that Flock applied his mind and he gave advice was suppressed. Then there was David Makapela, who was a SARS, attorney hired by SARS after 2014, after I was out of the place. He also gave an opinion. And he also gave an opinion that said, this is lawful. So she ignored those two pieces of evidence. She ignored the evidence that I gave and Commissioner Magashula gave, which is that there will also be a saving for SARS. I think the third thing is this. I can't give this to myself. I made the request. It is up to the commissioner to decide on this. And the commissioner applied his mind, and he decided that as a commissioner, he wanted to still have me around. And on that basis, he made the decision. Now, that judgment it's in the annexures, and they are quite lengthy comments on them, and I just want to mention some of them. Firstly, the PP failed to cross the jurisdictional hurdle of the 2-year limit. And my understanding of this, the judgment is saying simply, when you decide that in spite of it being 2 years, you want to look into these matters, then you have to say there are exceptional circumstances. And you've got to be honest about it, and you've got to put it up front. And she did not do this. And then the report says in paragraph 57, regardless of the absence of jurisdiction, the report is totally flawed and false to be reviewed and set aside. So in other words, after finding that in the first instance, this matter should not have been entertained, the judges say, no, let's look into the rest of the thing. And then they say, regardless of the absence of the jurisdiction, the report is totally flawed and false to be reviewed and set aside. So the 123 says, we are of the view that the errors of law committed by the public protector in coming to her decisions and or findings is material. We will show that the public protector was wrong in law. So this is not only about facts, it's about law. She was the one who made a mistake of law. And then it goes in a number of things. And one of the big things is that she insisted that retirement actually means, in the context that we used it, means that I should have left SARS. And I didn't leave SARS, and therefore I hadn't retired. And the judges looked at it and they said, no, this is what retirement means. You're wrong to come to that. So I think it's long, but if you can look at the judgment, you will see that all of those things. Thank you.
I think you've covered me, Mr. Pillay, in some of identifying some of these errors, because we want to better understand them as a committee, considering that we're dealing with the public protector and the motion before us. The second issue, Mr. Pillay, was around the establishment of the intelligence unit at SARS. I referred it to that. was the establishment of this particular unit ruled illegal or unlawful in any court of law, Mr. Pillay?
No, thank you, Honourable Member. So on the civil side, and that is in report number 2, the court has gone through this in some detail. And firstly, it says to the public protector, you have these allegations, but you did not interview anybody about that. You didn't, I'm not talking about investigate, but you didn't verify the allegations. So you accept the allegations uncritically. Okay, then you give notice to the implicated parties. They send you affidavits, sworn affidavits, unlike the complainants who have not given any sworn affidavits. And you dismiss the evidence totally out of hand. I mean, it'll take too long, but if you go into the judgments and you look at them, it actually says that the public protector has depended on mere assertion. There is a very, very strong that was quoted. I hope I can find it quickly because I don't want to waste your time. It was 195, and where it says one further evidence in the way the public protector approached Mr. Pillay's evidence in the review application. In her answering affidavit, she adopted a dismissive attitude to what she terms Mr. Pillay's views. And this is clear from the following passage taken verbatim from her. She said, the public protector was not bound by Mr. Pillay's views on affidavit. She considered them but found they were a defense of an indefensible establishment of a spying unit. So she's actually made up her mind. It go to 194. It is important to note that no other party in these proceedings, including the public protector and the EFF, has sought to respond at all to what van Lochenberg testified in the affidavit that he deposed. What he says stands entirely uncontradicted and unchallenged. The public protector has put up no facts or evidence, either in the report or in affidavits filed in the matter, that refutes the evidence provided by Pillay and now van Lochenberg. All that she has done in her answering affidavit is belabor evidence put by Mr. Pillay as simply his views and opinions. It is plain that the public protector has approached this investigation with an unwavering commitment to her own preconceived views and biases. And then let me just finish that off with just two things very, very quickly. The judgment examines the founding of the unit, the legislation. And it says the existing legislation does not say it is unlawful. It's not unlawful. And then it says, if you want to then look at the activities, then you must look at the activities of the unit. The unit carried out 81 projects. The public protector did not look at those projects. The only thing she's focused on is one particular thing around which there are allegations. And I think this is the big problem. You've got to come at it, as the law says, as a precedent says in previous judgment, you've got to come at this with an open mind.
So from my understanding, from what you're saying,
thank you. That will be our last. That will be our last point.
All right. Let me just bundle it up this way, Chair. Mr. Pillay, just on two things you can answer at the same time. In all of these three matters, but in fact the two that have been finalized because the other report is under review, have there been any cost implications? And I ask this because there's been an allegation around reckless litigation in the office of the PPE. So have there been any costs that have been incurred or awarded by the court that might have costed the public protector? And then my last question to you is this, Mr. Pillay. In dealing with the motion, on these three reports that you've written down in your affidavit, what would you say constitutes bias, misconduct, or incompetence of the public protector? Thanks, Chair.
Wow. The honourable member, there's actually a part of the judgment in the second report that actually deals with the bias. And it's long. It's about 4 or 5 paragraphs. And the judges actually conclude that she has taken a biased view towards me on that issue. So it's there. I don't want to read it now. I think it will take time. But if you look towards the end of that judgment, you will find it there. On costs, the legal team has had that question from evidence leader. They're working on it, but I understand it's in the region of about 4 million. So,
Okay.
thank you. Thank you.
Thank you, Mr. Pillay. I now recognize Honorable Mailam.
Thank you, Chairperson, and you will excuse me if I don't put my video on. I'm driving, so unfortunately that doesn't work. Mr. Pillay, thank you very much for your evidence so far. Just a couple of quick, easy questions. You've indicated on several occasions that you are not a lawyer. So as a layman, is it your understanding that the Constitutional Court's decisions are the end of the road, that's it? You can't go further than that?
Indeed, that is my view, uneducated view on it. I think it, and I, in a way, and I'm not talking about me, but it would be disastrous for the country if we say that the court's judgments are just an opinion. Although I agree that in applying the judgment to a particular situation, we must look for relevance. Thank you.
Thank you. So in the case of your pension fund payout,
yes,
there has been no finding of unlawfulness in that process. Is that correct?
That's correct.
And that's gone all the way to the Constitutional Court, and they have said there's no problem here with the lawfulness of the payout.
Yes, indeed, and it went through. If you from the High Court upward, it goes through. It's about 15 judges in the end, and it's,
okay,
it's final.
So let's put that to one side. Let's not dispute the facts of the matter because that's now been finalized by the judges. What did the judges say about the conduct of the public protector in terms of that particular matter?
They say, and of course it's in more detail in the second case. But basically, it's the same thing. The one issue is that she didn't have jurisdiction because the issue was more than 2 years. That itself is not the
sure.
Serious. It is that she must have reasons. But she must have reasons that say there are special reasons. And I think that is the common problem. Yeah, she doesn't believe that she actually has to provide the reasons. So I think that's the one issue. The second issue is that so somebody makes an allegation, and if I'm not sure, I think it's in this case. The allegation is made. It's an anonymous allegation. And what I know and what the court says is that in many of these instances, you have to do like a first level check on the people who are making the allegation on the allegation before you run off and do a deep investigation. And this is what happened in this case is precisely what happens if you run off on on a deep investigation. So one should be looking at those things. And by the way, the court doesn't actually say it. They say it indirectly. They always said that the only people who have provided evidence in sworn affidavits was Mr. Lochenberg and myself. A lot of these allegations are not in the form of sworn affidavits. So I think that's the other matter that they pointed out. I think one of the other things is that when it comes to remedial action, we have asked that, look, you please tell us what's the remedial action so that we can then respond to it before you formalize it. And she refused that. And the court found that because the nature of a remedial action is so intrusive that there should be audit, which there wasn't. There are other matters, but I've now forgotten.
Mr. Pillay, maybe I can ask you this with regard to the pension fund matter, and I'm going to basically ask it in the form of yes/no questions. Did the court find that her findings were legally sound?
Her findings was not legally sound.
Okay.
Because, for example, she found that I did not retire.
Okay. Did the court find, or did the court make a ruling with regard to her findings of fact?
Fact and law, yes.
Okay, and the rationality of her processes?
It's often referred to as irrational.
Okay. I'd like to move on to the intelligence unit matter, and I have just one question in this regard, and that is this. Were any of the reports that were relied on by the public protector still in good standing by the time the public protector issued her report?
I don't think so. I think some of them would have fallen where she was in the process. Certainly, Kroon apology came via the Judge Nugent Commission, and she would have known, and we raised it. We raised the issue of Kroon's withdrawing of his statement. So a lot of these things you knew. The NDPP's withdrawal came rather late, I think in about 2020. That would be the one that came late. But most of the other ones which could fall had fallen. And I say that because it's not possible to withdraw somebody's opinion, which is what the Skakane report.
Okay, my final question then is, with regard to the intelligence unit matter, and in particular the IGI report, the court has found, and correct me if I'm wrong here, the court has found that report should be set aside. Is that correct?
Correct.
So it has no value whatsoever, and raising it now is meaningless.
No, absolutely. Okay.
Thank you very much, Mr. Pillay.
Thank you.
Thank you, Honorable Mylan. I now recognize Honorable Sukas.
Thank you, Chair. Mr. Pillay, thank you for coming before this committee. I have a few questions that I want to ask you. And my first one is that, could you explain how the barriers of apartheid and political activity limited your educational opportunities, and how your work in exile prepared you for your future success?
All right. Look, I finished matric in 1970, and I went to work in the construction industry, but in an administrative position. And I roughly worked there for 7 years, well, until 77 when I went into exile. I was part of the MK and part of the ANC political underground. And I did a number of things there. I was in the senior political committee, and I was in the political military committee in Swaziland. And finally, I was a project manager of Operation Vula. So you could say, in a sense, I did managerial work. I did clandestine work, underground work, and I played a managerial role there, and that helped prepare me for the job situation. I came back to South Africa, and in '95, I was given work to do in intelligence in the Strategic Affairs Office. I worked there for some time until I went to SARS. And somewhere in between, when the negotiations were taking place in the TEC, I participated in CODESA, and then I also participated in the TEC administration. Thank you.
So much of your skills you have developed as part of your work life, rather than an academic institution.
Yes, true.
I also just, the process of this committee is new, and it's first of its kind. You mentioned today, you stated that you felt badgered. Did you feel the committee procedures assisted you enough to protect you in giving your evidence?
I thought it was a bit better today. I think in the previous days, I think witnesses were badgered even more. But in general, I do think that should not be necessary to badger witnesses. The questions should be put, the answers given, and then the evidence leader can have a view. The representative of the public protector can have a view. The committee should make would analyze all of that and make their decision.
Chairperson? Chairperson?
Just a pause, Honorable Sukas. Advocate Mpofu.
Yeah, I need your protection, Chairperson. I can't allow members to, if they want to attack me, must attack me frontally. Don't use a witness. And I cannot be insulted by a witness here about whatever happened in the past. I explained to this man that I was not badgering him, and I just wanted an answer. And therefore, I don't know why. Firstly, why you allow for this to be raised, and it's just unfair, Chairperson. If people don't know what the meaning of cross-examination, I'm not responsible for that. Thank you.
Thank you, Advocate Mpofu. I guess that would have been a point of order, just to indicate to you that point of order is not sustained. The member is in her own right to ask the questions from the witness, and there would have been no mentioning of you in the process.
Oh, I'm not the representative. Who's the representative of the public protector?
He did not say the representative.
That's what you just said.
No, Advocate Mpofu. He said evidence leader and the public protector legal team would have a view, and then the committee would make a decision.
That's fine, sir.
Proceed, Honorable Sukas.
Mr. Pillay, thank you, Chair. As part of your affidavit, a quote is
Chair,
referenced.
sorry. I'm sorry, Honorable Secretary. I'm really sorry. Chairperson, I apologize for interrupting the member. Yeah, I'm simply saying that, Chairperson, I expect you to protect me as you protect everyone else. And if this member from the ACTP who's speaking now, if he has a problem with anything that I did, I'm here to deal with it. But let's not get it via Mr. Pillay. I'm here. I'm available.
Thank you, Advocate Mpofu. I protect everybody in this meeting.
Thank you.
So I also want to protect Mr. Sukas now. Please proceed.
Thank you, Chair. Mr. Pillay, as part of your affidavit, a quote is referenced coming from the Public Protector report that states, "The views on state capture are just that, views." What are the views that are being referred to in this extract?
I think I made the point in the affidavit. Obviously, I'm just talking from memory now. That the narrative being pursued by the Public Protector is a narrative that has been made by as part of the narrative of the people who've put us under tremendous pressure over years. That is, in my view, part and parcel of the state capture program. That is my view.
This is my last question. Mr. Pillay, who would benefit from the destruction or the closure of the SARS high-risk unit? What was the purpose or the reason of existence of the unit?
Okay. I don't think there's a simple answer to that. SARS was a very efficient and an effective institution. And the truth is we made a lot of enemies over the years. There are ex-employees, and as we've had over these days, there are disgruntled employees. There are people who have been under investigation by SARS. There are actually also criminal elements. And there are, a lot of it is about political fixes. The criminal elements includes the tobacco mafia. And they all have been trying to get at SARS over the years. We have given a long list to the Public Protector. We've given lists to other people. And we have raised these issues over the years. And so we have had, probably from about 2009, continual attempts to breach our walls. And they only succeeded to really breach our walls in about 2014. Included amongst those groups would be state employees. And in my view, particularly some of the people in the SSA, where I say that was the real rogue unit, and they managed to flip the narrative around and put the focus on SARS. At that time, in my view, and it's probably a biased view, SARS was the best organized state institution. And even though it was small, we had the best organized enforcement capacity in the country. We reached a point, and it's very, very important that because people learned a lesson that in South Africa you keep pushing the boundaries and you'll get your way. One of the few places that stood consistently is SARS over the years. But in my view, we lost political cover from about 2013, 2014. I've raised these issues, by the way, directly with the then president, saying that we should not be allowing the people to destabilize SARS. If you don't want us to be there, tell us and we will go. I also made the president aware that around about late 2013, 2014, his legal manager was organizing meetings with the person that was destined to be the next commissioner. So there was a whole organized program, which of course we now come to know as state capture. And they finally broke through the gates of SARS. We stood firm on not allowing any politician, including ANC politicians, from abusing SARS. So we accumulated a lot of enemies over time.
Thank you. Thank you, Mr. Pillay. I now recognize Honorable Mananiso.
Thank you, Chair. Chair, am I audible? Thank you, Chair.
Yes, you are audible.
Yes. Good afternoon, Chairperson. And let me greet our evidence leaders, Advocate Mpofu and team, and as well Advocate Bauer and team, and welcome Mr. Pillay. Mr. Pillay, considering the fact that the mandate of this committee is to determine whether the PP is incompetent and that she misconducted herself in the office, do you believe she is incompetent or she did misconduct herself, or both? That's my first question.
Thank you, Honorable Member. It's a loaded question. What I can do, what I can say is that in the two judgments which we have now, and the one is finalized and one is pending a leave to appeal, the judgments are really, really very, very clear. I quoted some of it today from a document I was reading. These come directly from the judgments. The judges, and remember, these are the different tiers. So on one matter, I think there's about 40 to 15 judges. The other matters a bit less because the constitutional court hasn't yet engaged directly with the matter. They use words like irrational. They use words like bias. They used words like did not clarify the allegations. They use words like ignored evidence. So it's actually replete throughout. And on my small matter of my matriculation certificate, it's unbelievable that it became such a big issue. And I was in her presence and she asked me if I had the certificate. I said, yes, I have. And in the accusations also is that she has a preconceived view of things and she doesn't allow the facts to interfere. And more than the facts, which I understand are open to interpretation, there are many, many times it's said, this is wrong in law. So then the committee has to apply itself and again, to be fair to the public protector, you've got to examine all the cases and weigh it up, and on balance, make a decision. Thank you, Chair.
Okay. My second question, Mr. Pillay, is that do you think the PP used their powers to embarrass and humiliate you when she was asking you about your matric certificate in front of the public?
Are you, sorry, Chair, to you, are you talking about today or are you talking about during the process of the litigation?
During the process
of the litigation. I really don't know. I can't fathom it as to why this would happen unless she's really decided this is an evil person, this is a bad person, and this is a target, and we have to do what we can to fight this person, get rid of this person. It's possible, but it's very difficult for me to actually venture what it was all about.
Okay, so can you just answer me yes or no? Were you humiliated or not?
Me as an individual, I've been under the cosh since 2014. My family tells me I have a very strong ego and it's not possible to humiliate me. I say, actually, I have no ego. So people can insult me. It's really, really not a problem. So I think the bigger issue is that a lot of people have suffered. And not only in SARS. I mean, there's Anwar Dramat, there's Robert McBride. A lot of people have suffered. They've been thrown out of their jobs. They've been charged. And institutions have been ruined, which is probably the bigger issues. Thank you, Honorable Member.
Okay, as a follow-up question to what I have asked you, do you think the PP was using the might of her office to harass you?
Well, it's difficult for me to say, but I want to maybe cite an analogy. Just before I was suspended in SARS and eventually thrown out, I was walking the passage. I went to our HR manager, who was a seasoned HR manager, and I said to her, look, you're going to charge X. Please don't do this because it's very difficult if you do this. It'll put the new commissioner in a difficult situation. One of the things she said would be stuck in my mind. And I think it describes what some people show. That she said, these people must know we mean business. So in some instances, some of this is about setting an example. I got a message indirectly from the then Minister Lynn Brown towards late 2013. And the message said, the people in SARS are going to be attacked and they're going to be driven out of their jobs and they're going to become untouchable. That message was given to us by a journalist. She drew an affidavit. And when we went to the media ombudsman to challenge the Sunday Times, we did present it there. So the affidavit is around, it exists. So I think to some extent it's about teaching people a lesson, and not only the punishing the people itself, but about teaching other people that we mean business. Thank you.
Okay. As I conclude, in reference to paragraph 8.3 of your affidavit, wherein you indicate that the PP relied on untested hearsays and gossip relating to the SARS investigation unit. Please elaborate what informs these assertions.
Okay, so let me say one thing, that the allegations about SARS started about, I don't know, 2009, 2010. And the allegations kept getting added on. There are a number of what we call dossiers. They're usually poorly written dossiers. And they circulate, they go to media, they go to politicians, they've gone to ANC politicians, they go to opposition politicians, and they trying to besmirch the name of SARS. Some of them are weird. Some of them are about, we have an arms arsenal in SARS, that we're trying to control the government. Some of it is very, very personal. I'm supposed to have children, employees in SARS. By the way, which employee doesn't have any children at all? So that it builds, and every time you resist it. And by the way, over the years, we've gone many times to the newspapers. When politicians have received these dossiers, we've gone to them, we've explained things to them. And when it doesn't get traction, it morphs, it keeps changing. I mean, at times we were accused of being anti-certain people because that person is pro-Zoom. Later, the accusation is we are against that person because he's anti-Zoom. So this has become a convenient thing to use. So there's all sorts of allegations flying around, and the ones that the public protector investigate and others is only part of it. There are lots of other allegations. And all we are saying, and I think the judgment is saying there, is first look into the allegations before one runs off into an investigation. Thank you, Honorable Member.
Thank you. Thank you, Mr. Pillay. Thank you, Chair.
Thank you. And I recognize Honorable Heron.
Thank you, Chair, and thank you, Mr. Pillay. Mr. Pillay, I'd like to just start with the letter that you sent on the 26th of August 2014, which was referred to in the judgment. In cross-examination, your first statement was, one of your first statements was that the City Press article of the 16th of August 2014 prompted the IG investigation and an internal investigation by Sikakana. So the letter of the 26th of August 2014, which is around that time, which was sent to the Public Protector's Office, and that would have been Advocate Madansela at the time, contained 23 documents in support of the submission you made to the Public Protector. So what was going on in SARS before?
Just pause, Advocate Heron. Honorable Heron. Advocate Mpofu, please mute.
Oh, I'm sorry, Chair. My hand is up. Sorry, I wanted to come in before Mr. Heron, but I'll talk later.
Proceed, Honorable Heron.
Thank you. So, Mr. Pillay, I just wanted to understand what was going on before at SARS, that you had 23 documents that you could submit and supplement your original founding affidavit.
All right. So, and thank you, Honourable Member, for the question. As I was saying, there have been allegations about SARS for a long time. And it began to take the form of dossiers. And by the way, the allegations were about SARS, and later it's also about National Treasury. And usually there are 10, 12-page documents, and they make a lot of allegations. And our response to Advocate Thuli Madonsela was also about the allegation about that unit. And the response at that time was, okay, we looked at this and the only thing we are interested in is on the human resources side. When it came to the recruitment of people into the unit, was that done properly? And we responded to in the end, to all of these things. So I'm sure if we put all of these dossiers together and all of these allegations, they would make quite a few large files. They've been there for a long time. They've been in the paper. I mean, for example, Michael Picha, we talked about him. He was a poacher. We fired him. And he said when he was leaving, he was trying to get more money from us. He said, listen, I'm going to go to the media. I'm going to go to whoever I can go to. And he did. He produced a dossier of his own. So there are a number of these things flying around.
So, Mr. Pillay, the documents that you submitted with your letter, were they investigations that were done internally, or were they all these dossiers that were floating around that you then forwarded to the public protector?
If my memory serves me, and that's a long time ago, is that these would be relating to allegations, and it would give our side of the picture. It would go into why these allegations are not true. And as I say, in the end, the only thing that the Advocate Thuli Madonsela wanted more information was on the recruitment.
Thank you. I've been trying to keep track of all these investigations that were done. And you say that, in your evidence, you said the City Press article prompted the Sikhakhana investigation, and then there's the Brassy investigation or report, there's the KPMG report, Mr. van Lochenberg mentioned Kanyana report, there's the report by Judge Truan, and then you mentioned that there was Advocate Trengrove provided an opinion. So is it true? I mean, is it correct that Brassy, Sikhakhana, KPMG, Kanyane, Kruan, and I think there was also an investigation by Mashiani attorneys, that these reports all in some way or another found that the investigative unit was an unlawful unit?
No, honorable member. So let me correct something. So there was an article on the 10th of August 2014 that talks about a rogue unit at the SSA. As a result of that, the Minister Mahlobo instituted an inquiry which was conducted by the IGI. Terms of reference was to be a focus on the rogue unit in the SSA. That happens almost the same time as there are articles in the Sunday Times, initially about Johan van Lochenberg and a person called Walter, where she made a lot of allegations about van Lochenberg. And she made these things public, newspapers all over. She wrote us pages and pages of documents. As a result of that, I appointed the Kanyane panel to look into this matter. They looked into the matter, and in the end, they couldn't go forward because they asked the lady to put her allegations down on an affidavit, and she refused. But the allegations continued. And I then decided, no, maybe this panel wasn't good enough. Let me appoint Advocate Skakane. The terms of reference was in the context of the accusations against Johan van Dochenberg. Again, which allegations began to morph. There were allegations that he was leaking, that he had leaked or given information to her, allegation that he's wrongdoing, and it was growing. So that was the terms of reference. There was no terms of reference to look into a so-called controversial unit. But somewhere midstream, just before or just after the appointment of the new commissioner, the terms of reference changed. The report says the situation lent itself to a change of reference, terms of reference. It's a very queer formulation. And so then the focus shifted to this unit, which coincided with the shift of focus in the IGI, also to the SARS unit. And in the Sunday Times. And obviously, the Sunday Times comes slightly before that, and the Sunday Times kept us up roughly 34 weeks of articles. So that's laid the basis. We've had all the accusations, we had accusations before, but that laid it. That created actually an absolutely new setup. Now, coming back to this, the specific, all right, let me say one more thing, is that when the new commissioner is appointed, Tom Moyane, he institutes, within weeks of being there, he institutes the KPMG, the appointment of Triple M attorneys, and he starts the investigation. In fact, Judge Nugent says, in fact, I can't do better than Judge Nugent, but I don't remember his word. He says, basically says, this was a man with a mission. He came there and he had strategized a year earlier, at least a year earlier with Bain. And one of the things was clear is that you need to neutralize certain people. Judge Nugent's view is that certainly myself, Piet Richer, and others were first in the firing line. So all of these things were instituted, my view, to get rid of us and to take firm control of the institution. Now, to come back to the specifics, the Skakane report is wrong on whether the laws were breached. The judgment is now clear, but before the judgment, Trengrove gave legal advice, Counsel Trengrove gave legal advice to SARS under Tom Moyane, which advice was suppressed. We only got to know about it later when there's discovered.
Can I ask Mr. Pillay, the chair is not going to give me a lot of time, and I've only asked 2 questions. I'm really trying to understand out of all of these reports. Yeah. I mean, I hear you that they've been set aside and they're wrong and all that, but I mean, Brassi, Sikakana, KPMG, these reports all found that there was a breach of the law.
Yes.
Kroon made a statement, which he later retracted. We understand all that. But I'm trying to, there's a long list of investigations post the City Press article, and they all find something wrong. I mean, we saw senior counsel at the prosecuting authority drew up charges. Yeah. Am I correct?
Yes, indeed. And all of them have failed.
So, I mean, the reason I'm asking this is that we have to decide whether the public protector will make a recommendation as to whether the public protector is guilty of misconduct or incompetence. And I mean, if she's wrong about all of this, which the courts have found, she's in pretty good company being wrong.
Well, Honorable Member, it depends what you mean by good company. I mean, the Skakana report is an abominable report.
Sorry, what I mean is that KPMG is a reputable firm, or it was at the time. Brassey is an advocate. I mean, there's no reason to question his integrity, is there? Judge Kruin, you know, these are the public prosecuting authority.
So I think it talks to the power of authority, about influence, how people wield influence and get things to be done. And I must point out again, it's just not SARS. It happened to Robert McBride. It happened to Dramat. It happened to your shadow Minister of Justice. I've forgotten the name now, Breitenbach.
I'm not from the DA.
Oh, sorry. I'm making a mistake.
That's racial profiling.
Sorry. Yes, indeed. I apologize. It's happened in so many instances, and it's not just that there were the reports. There are also instances where there were opinions, like Macapela's opinion about the pension, and about Trimgrove's opinion about the founding of the unit and the activities of the unit, according to the law, which in my view were good opinions, and they were suppressed. So you actually have two processes. You have the advancing of a particular narrative, and you have the suppression of anything else.
Mr. Pillay, let me move on.
That will be your last.
I've only had two questions.
It's how you controlled him. It's because when I give you time, you are in charge of your time.
All right. But I've only got two more left. Can I have both of them?
Quick, please.
Yes. Mr. Pillay, just I want to understand this arrangement between the DSO, or that was where members of your staff were able to assist the National Prosecuting Authority, or the DSO, with installing of equipment as a kind of as private individuals while they're employed by SARS. I think that was your evidence. So I mean, was this a practice that is permitted, where staff members can sort of moonlight and provide services while being employed by SARS after hours?
Honourable Member, at that time, that was allowed, as long as the companies that one had were declared. We had something I call this a DOPI, Declaration of Personal Interest. So as long as you declared that you're doing some things, as long as it is done after hours and it doesn't interfere with the SARS work, it was permitted.
Thank you. I just have this last question, Chair. Mr. Pillay, I think on more than one occasion, about your retirement, the retirement case, you said that you were retiring from the pension fund.
Yes.
And I don't really understand that. Are you saying that you can retire from the pension fund and continue employment? And because I think the Act actually talks about retiring from the public service. So what did you mean by retiring from the pension fund?
Oh, yes, so let me clarify. My intention was to retire. I wanted to access my pension fund. Let's say that. But the way things were at that stage, accessing your pension fund meant retiring from SARS. I was up to that stage of what is called a full-time member. And then if SARS wanted me, then they needed to rehire me on contract. So that is the explanation.
Sorry, so you were actually retiring, not retiring from the pension fund?
Well, in the ordinary meaning of retiring, in the ordinary meaning, one would retire, one would leave an institution. I'm now retired. But at that stage, I wanted to access the pension fund, but I couldn't access the pension fund by continuing to be a full-time member of SARS. It was not possible. So in other words, I had to not be employed as a full-time member of SARS. My status, if SARS wanted me there, my status had to change from a full-time member to a contract employee.
Okay. Thank you, Mr. Pillay. Thank you, Honorable Heron. I now recognize Honorable Lawtrit.
Thank you very much, Chairperson. I'm also not switching on my camera as I'm sitting with load shedding at this point, so I hope my connection is stable. Mr. Pillay, thank you very much for your testimony today. I don't have many questions as a few of them have already been covered. I just want to find out from you at the time of your appointment. I think you said earlier that there was no requirement of any degree for your appointment as a deputy commissioner. Did I hear correctly?
Yes, and the judgment said so. There was no requirement. And by the way, there wasn't such a requirement even for the commission. I think it's now been changed.
Okay, so if you say it was changed, you believe it's now a requirement that you should have a post-matric qualification?
To be a commissioner, yes.
Thank you. Mr. Pillay, when did you join SARS?
1999.
And if I heard you correctly, you said that you were appointed in a position of a general manager.
That's right.
And what was the time lapse between your appointment as a general manager and your appointment as a deputy commissioner?
I'm not sure the exact date, but I think I was appointed deputy commissioner around 2010.
Okay,
so it's about 10 years.
Okay, thank you very much. Then I just want to turn to your affidavit, 8.4 of your affidavit, and that is where you refer to 192, 193, and 194 of the High Court judgment. In that particular case, the High Court found that, while it was mentioned that the public protector in her answering affidavit mentioned the fact that you weren't candidly and openly in terms of dealing with the issues, that you only gave some views, that you had political narratives that were irrelevant, and you also avoided giving credible and straight answers. Could you perhaps remember whether during your interview with the public protector, whether she ever indicated to you that she had problems with the way in which you were answering her questions?
Honourable Member, in that instance, the interview came early on, if I remember correctly, before the written submissions were made.
Okay, thank you.
But maybe I could say there was no attempt to engage and say, on these matters, this is fluffy, be more specific. There was no such engagement.
Thank you very much. And then also just to confirm for my own notes, that you did not receive any Section 79 letters in the second and third matter.
Well, we did not receive 79 letters when it came to remedial action for any of the three matters. And then on the last matter, I didn't receive even the initial Section 79 notice.
Okay. Thank you very much, Mr. Pillay. That's all from my side, Chair.
Thank you.
Thank you, Honorable Lothridge. And now recognize Honorable Klape.
Thanks, Chairperson. My apologies, I'm also sitting in load shedding. Mr. Pillay, can you confirm to the committee that your appointment as SARS Deputy Commissioner was not unlawful? And when you applied, were the requirements, qualifications stated for this position?
Thank you, Member. By the way, there is no job description for a deputy commissioner. It's not a position as such. There were no advertisements. Not long before, or rather, I think around about the 2010 period, the minister decided to appoint 3 commissioners, deputy commissioners. It was said at that stage for stability because Commissioner Gordon was on his way out. He would move on. And at that stage, we didn't know, and we didn't even know that he would be Minister of Finance. There was even some talk about it going to Transnet. So for stability, the minister wanted to do that. There were no particular duties, nothing. There was no qualification. And 3 people were appointed. We did not apply, and as I say in my first response, I said no, man, you can't be doing this, because I felt some other people had been overlooked, at least one other person had been overlooked. So it was just a title, no salary attached to it, no job description, nothing. Thank you.
Thank you, Mr. Pillay. Now, do you think the PP's intentions were malicious when she conducted the 3 investigations against you and made findings? And please substantiate your answer.
Chair, I really don't want to answer that question directly. What I do want to say is that, and what I've said many times today, is that in the 3 matters, the judgments are quite sharp and quite clear. I don't want to make this a personal matter about being malicious about me or whatever. And my own view is that the evidence is there. You've got to see whether it's relevant. And you've got to make your decisions, but I will leave it there. Thank you.
Thank you, Mr. Pillay. Thank you, Chair. That will be all from me.
Thank you, Honorable Klape. I now recognize Honorable Maute.
Chair.
Before Honorable Maute, I recognize you, Advocate Mbof.
Thank you, Chair. Sorry, I think you forgot about me. I had said I wanted to speak after Honorable Heron. No, Chair, I just want to raise some issues of protection again. Please, Chair, we really beg you, can you ask your members to refrain from asking questions which suggest that the public protector should not act on complaints that are raised with her. In other words, if she receives a complaint and then we say now it's malicious when she investigates it, because that I don't think that's part of the terms of reference of this committee. And if it's been happening and we've basically not trying to tolerate it, but now already there's been 3 instances where either the witness is asked whether he thinks that she's guilty of misconduct, which is also completely irrelevant. But we understand that people are not lawyers. They don't understand that you can't ask a witness about the very fact that is to be determined by the tribunal. So it's just those kinds of things, Chair, because they're just prejudicial and unfair. And I'm not saying that was the intention of the members, but it's just, I mean, if somebody says, what if the public protector did not investigate a complaint, then we're going to say she's guilty of misconduct. If she investigated, then she's malicious. And it's not, these are not investigations that were initiated by the public protector, but by members of the public. Thank you, Chair.
Advocate Mpofu, maybe I need to just make this point here. I hear you and I take your point, but I can't sustain it. Members here, I'm going to allow them to ask the questions in the manner they deem fit in relation to what the kind of information they want to get from the witness. This is a committee that is doing the inquiry. I do not even want to suggest that, because that's not what you are saying. I don't want to suggest that you want them to ask questions in the way that makes you comfortable, because some of these questions are going to be very uncomfortable. That's not
Chair.
what you say.
No, Chair. Sorry.
No, you can't stop. I'm speaking.
No, because you are going on a different direction.
No, allow me to speak. I allowed you to speak, even if I don't agree with what you're saying. Just stop doing that.
Yeah, don't shout at me. Just carry on.
I'm not shouting you. I'm asking you to stop doing that.
No, it's fine, Chair. I'm sorry, Chair. I'll come in after you. Yeah.
You don't have to come in after me. Why would you come in after me? I'm going to make a ruling now.
No, but I want to come in. But I also want to make a point.
The point I'm making is that allow members, this is now their time, to interact with the witness, to ask questions to the witness. Our directives are very clear on issues of relevance. We would have spoken about that for the last 3 days. And we have an approach about how to attend to issues of relevance. When a member is asking if, in terms of this judgment, which would have said the public protector has misconducted herself, if that was enough, there was never going to be an inquiry. There's an inquiry precisely because we've got to get to the bottom of that. We're not just going to take what court judgments are saying. Hence, this committee has no predetermined kind of an outcome. So we're going to do our work, look at facts and evidence, not just judgments. Doesn't matter what court that would have been.
With respect, you don't understand the point I'm making. I accept what you're saying. That's not the point I'm making about predetermined things and what. I'm saying and I'm entitled. The reason I'm here, which is in your directive.
I've not finished.
Oh, sorry, Chair.
And you know that.
I thought you were. No, I thought you were.
I'm not finished. You would know when I'm finished.
How will I know?
Thank you. So I want to make sure that, because it can't be that every time a member speaks, you have to make a comment about how this member is asking a question.
When did I do that? When did that happen?
It's just unheard of. You've been continuously doing this up to so far.
No, Chair.
Please don't create a dialogue. Do not create a dialogue, Advocate Mpofu.
Yeah, but don't misrepresent the facts.
On the platform.
Don't misrepresent the facts. Every time a member speaks, I speak. When did that happen?
I'm not misrepresenting the facts.
You just said every time. That's not true.
Order, Chairperson.
I'm on the platform. Stop speaking, Advocate Mpofu.
Order, Chairperson.
So I want to complete this. I note your order, Honorable Nodat. I will give you an opportunity, because I don't think we can continue in this way. Constant kind of disrupting and trying to determine in what way members should be asking their questions. So, and I want to proceed to the next members.
Honorable Chair.
Your order, Honorable Nodada.
Honorable Chair, can I please speak before that?
Chair, please note.
Chairperson, there's an order, Chair.
Yes, Honorable Nodada, I recognize you.
Thank you so much, Chairperson. Chairperson, we've got rules here. We've got directives here. When a member is speaking on the floor, they're not supposed to be interrupted. If you're making a ruling as a chairperson, you must conclude that ruling, you must hear what that ruling is, and then you must take it from there. But these interjections are really disrupting the whole meeting. It's making it degenerate. And on top of that, the point that has been raised is completely out of order, Chairperson, because we are here to get the information that we need to get. We are legislators, we're not lawyers, but we're here in this committee to get the information that we require to do the work of legislators. So please, Chairperson, can you make sure that the meeting is in order and we're not disrupted when we're doing our work, because we don't disrupt people when they're doing their own work as well. Thank you so much, Chair.
Really? Chair.
Thank you, Honorable Nodad. Stop responding and unmuting yourself and speak without being recognized, Advocate Mbofu.
Okay, Chair.
I'm going to give you for the last time and I'll make the ruling.
All right. No, Chair. So, thank you, Chair. I'm sorry about that. Firstly, the member who just spoke is just, I don't know if he has been in this committee and how many times I've been interrupted unnecessarily and complained about it. I've never heard him protecting me. I'm saying, Chair, I have a right to object if there's an irrelevant point being raised. That's why I said to you patiently, I didn't want to interrupt the member. It happened about 4 or 5 members ago. And when Honorable Heron was speaking, I said I would have spoken just before that, but you didn't see my hand. It was out of respect because I didn't want to interrupt people while they're speaking. But it is my duty to raise objections of relevance. That's all I'm doing. I will never stop doing that while I'm still here. I have to do it because if I don't do it, then it is going to remain on the record. You can rule against me, that's fine, that's your prerogative. But the rules say that you, Chair, and that's why I'm addressing you, you are the person who determines when there's an objection about relevance. And you can determine it in my favor or against me, that's fine, I'll accept that. But I cannot be stopped from raising an objection. That's just not how it works. And I'm not interfering with your things about predetermined outcomes and so on. I'm simply raising an objection, and it might be right or it might be wrong. That's it.
That's fair. That's fair. Thank you, Advocate Mbofu. The point you've raised is not sustained, and therefore I proceed. I now recognize Honorable Mautwe.
I raise the point of order as well, Chair.
Before you come, Honorable Maute, Honorable Zungula, your point of order.
Chairperson, in light what Honorable Nodada has said, I want to join in his views on the meeting must not degenerate. Firstly, Advocate Mbofu is well within his rights and responsibilities to raise a point of order, especially when it concerns to issues of relevance. Secondly, Honorable Nodada is very correct when he is addressing the issue of, when one person is on the floor, another one speaks. I've picked up that when Advocate Mbofu is addressing, you do interject, and that creates the dialogue that you are saying you don't want. And lastly, Chairperson, Advocate Mbofu must correct you when you are saying something that he did not say or something that is wrong. Just now, you stated that every time that members are asking or engaging the witness, Advocate Mbofu interjects or asks questions, and that is not true. We've been listening all this time. He's not addressing or wanting to comment every time a member of parliament is actually engaging the witness. So it can't be correct that when he's addressing that is not correct. You want to stop him and you don't want him to correct you when you are wrong in your assertion. So I wanted Chair to raise those issues. Thank you.
Thank you, Honorable Zungula. Your point of order is not sustained.
Chair.
I proceed.
Chair, sorry, I'm on another point completely. Sorry, Chair.
Chair, Chair, my hand is raised.
Yes, Honorable Lotrit.
Thank you, Chairperson. Not to belabor the points, but I do think it is important that you do rule on Advocate Mpofu's assertion now that this committee has a predetermined outcome. I think it is casting aspersions on this committee. We are here to listen with open minds, and I would honestly want you to rule in this regard. It puts us in an absolutely uncomfortable position if that is said of the members of the committee.
Thank you, Honorable Lotrit. I would have missed that point. Otherwise, we have consistently made our approach clear about that. I missed getting that. Advocate Mpofu, did you say that?
No, Chair, I didn't say anything of the sort. You, Chair, said that when you were responding to me, that you don't have a predetermined outcome and so on. So I said, no, I'm not on the point. I'm not on that point at all. So it's you, not me, Chair. But I mean, this is the kind of thing, but that's fine. Then we're not supposed to make corrections here. Chair, I wanted to make another point, sorry, completely different. We've observed that this witness is in the company of someone who keeps on whispering to him. Can we find out who that person is?
Thank you, Advocate Mpofu. I have not picked that up. I have not seen or heard it, but I will confirm with him as I go to Honorable Mautwe. Mr. Pillay, do you have a challenge where you are? Are you having people whispering around you?
He's muted. You're muted.
You're muted. You're muted.
Sorry.
Please mute yourself too, Advocate Mpofu.
Okay,
you've done speaking.
I'm done.
Mr. Pillay.
I have my family around, Mr. Chair.
You are in the house?
Yes, in the house. So I apologize.
Okay. Thank you.
No, Chairperson, no. I'm sorry, Chair. No, I don't know what you're doing now, Chairperson. I'm not talking about the house. I'm saying he has people whispering information to him, and you are leading him to say it's people in the house. Why do I care about people in the house? The people who are whispering to him, you must ask him about that, because that's wrong. It's illegal.
Yeah. Honorable Heron.
Yeah, Chair, I think to be fair and honest, we have to acknowledge that when I was asking questions, someone was whispering to Mr. Pillay about Sunday Times.
Thank you. Thank you, Honorable Heron. You are the new chairperson.
Mr. Pillay.
Yes, my spouse is here, and she whispers to me sometimes, and she's working also in the house. But I apologize.
Okay. Apology accepted. Thank you. Let's proceed, Honorable Mautwe.
Thank you very much, Chair. Good evening to you, Mr. Pillay. We previously had Mr. Johan van Logenbeck here as a witness, and he was at pains to explain that he does not like people using the word rogue unit. Do you also feel strongly against the use of the description of SARS intelligence unit, the rogue unit?
I feel strongly about it, and I think it says a lot about a person of whether you take objection to it or whether you want to use it.
Okay, and Mr. Pillay, it is clear that when you started working at SARS, your highest qualification was matric. So just for the record, affidavit paragraph number 1, wherein you stated that you were formerly employed by SARS in various positions, including as a deputy commissioner of SARS.
and you're employed in all these positions, only we stand at 10. Is that correct?
That's correct.
And okay, let's move from that one. Would you say that had the State Security Agency finalized the MOU with SARS at the time when there were discussions, including seeking of funding approval from the National Treasury to bring to the table its constitutional mandate to be the only entity together with SAPS and Defense to conduct intelligence surveillance, we wouldn't have had the whole rogue unit saga?
If I've understood the question properly, Honorable Member, the judgment on the unit has found that the establishment of such a type of unit is lawful. The establishment itself is not unlawful. There have also been other opinions. So the view that the unit in practice, its very foundation breached the law, was rejected by the judgment in the matter. But also SARS after 2014 received such an opinion from Advocate Trengrove, where he also said the founding of a unit in practice like the one that there was is not in itself in breach of the Constitution or of the law. Thank you. Check.
Okay, for the sake of progress, I'll move. Now, earlier on during the cross-examination by Advocate Dalimpo of Senior Counsel, he asked that all investigation that found the so-called rogue unit to be illegal relied on the fact that SARS does not have mandate to conduct intelligence surveillance. Did you agree to this? I missed your response on this. You were not very clear. Can you please respond?
Okay, so the opinion given to SARS, even after I left SARS, by Advocate Trengrove gives a very, very helpful interpretation of what the law allows and does not allow. So, for example, it can be okay to have surveillance in a state property. And in fact, there is an example that members of SARS enforcement, when they were expecting attempts to raid a SARS warehouse, customs warehouse, they were put to do early surveillance, and that was a state property. Another example is where there was a surveillance of a cigarette manufacturer, and the surveillance was not done directly by us, but there happened to be a Metro Police camera which was focused nearby. Our people were able to liaise with the Metro Police and use the footage to identify the movements. So, for example, counting the number of trucks that move in and out, and to be able to make an estimation of the quantity of tobacco that's moving in and the quantity of cigarettes that's finally, and comparing it with the quantity of cigarettes that's finally manufactured. So there is no blanket, my understanding, according to the judgments and according to the opinion of Advocate Trengrove, there's no blanket view that this is unlawful. It's about how it is set up and what its activities are.
So you are saying it was okay to establish the rogue unit at SARS in a nutshell? Is that what you are saying?
No, I'm saying it was okay to establish the type of unit that we established in SARS, bearing in mind that the type of unit that we finally established was different from the original conception. The original conception was actually to create something jointly with NIA and housed in NIA that would then use NIA's full powers. We did not succeed in that because at some point NIA grew cold on that type of solution. We then had to work out something for our own, and we tried as best as we could to stick to within the law. This unit, as Mr. van Lochenberg said, has carried out 81 projects over a period, and for most of its time, it only comprised of 7 people, and it did some real good work. Thank you.
Okay, in the interest of time, we'll move. Let's talk about your retirement saga now. Do you think it is fair that you benefited from package where SARS paid over 1 million of taxpayers' money in penalties? I mean, you now live in Holland, while majority of our people here in South Africa live in squalor. It's even a joke to you are smiling now when you've got your family around you, when our people are living in squatter camps.
So, by the way, I don't live in the Netherlands. I'm here because to visit the extended family, and I'm here because of the bereavement in the family. So I have not emigrated. I live in South Africa. I live in Pretoria. That's one. The second thing is that the package in which the penalty was paid for me was lawful. And secondly, the then commissioner pointed out, and I pointed out in my affidavit, that over a period of time, in fact, SARS saves, because SARS wouldn't be paying towards my pension and any other such extras. Thank you.
Okay, so Mr. Pillay, are you saying if it had been anyone in your position who did not have more than a decade-long relationship with Mr. Godani, would have been given their pension, SARS would have paid the money owed to GEPF, and any other person would have been rehired for a position that does not even have a job description?
So, you see, Honorable Member, that is a decision that the Commissioner, then Commissioner of SARS, and the Minister should make. Is it of value to them to have me? That is their decision, not a decision I make. And the Commissioner explains it in his affidavit. His view was that they should have me. They should have me there. They could have said no. Then my alternative would be to actually retire and take all my pension fund and move on. The decision was in their hands. It is not my decision. Thank you.
So do you know anyone, Mr. Pillay, in the whole of South Africa who ever retired, accessed his pension, and was rehired the same way that you were rehired as SARS, at the same salary with less responsibilities? Is there anyone that has ever gone through what you went through?
I believe statistically there would be. I showed you, or rather the legal representative of the public protector showed you 4 examples in SARS. I do agree, I actually don't know, but I think it would be that they did not have the early retirement benefit. Because remember, the early retirement benefit means that the calculation is pegged off at a particular year. the two gentlemen that are named by Advocate Dali Mpofu were hired the next day after they retired, but they didn't ask for, and they didn't need to ask for early retirement. They reached retirement age. Thank you.
How did the members of the rock unit got to be known to have the spying unit such that the private company contracted them to assist them in installing the spying unit at the NPA? And do you think there was a coincidence that it was your members of the rock unit that were awarded?
Okay, so firstly, I must say that the rogue unit that I know is a rogue unit in the SSA. This unit matters as before the court, and the judgment has said this unit has been lawfully formed, and thus far nobody has found its activities to be unlawful. So it is explained, as far as I understand, in that some of these people who worked at the DSO and some of these people that worked at SARS knew each other. They had reputations, and they were known to be people who had technical experience. So they phoned up somebody they knew. They didn't come to me. They didn't come to SARS as SARS. They spoke to individuals that they knew, and they made an arrangement with them.
And to your knowledge, was it the first time that such spying unit was being installed at the NPA?
I don't know, and as I say, I don't know that this is spying unit. This is for the DSO's purposes. I'm not aware. I'm not privy to what is happening within the DSO.
Okay,
the DSO.
Okay, let's move on that one, Mr. Pillay. So based on
your last points. Your last points.
Chair, how did you determine that? But anyway, I'll club my points together.
I determine in the way I do it. Thank you, Honorable Maud.
You don't have to respond to everything, Chair.
Go ahead.
Based on errors, Mr. Pillay, made by the court in paragraph 113, 115, and 116, would you say the PP was well within her right to apply for appeal? And should this committee rely on those judgments irrespective? And lastly, Mr. Pillay, just as a comment, I'm not sure when are you coming back to South Africa, because as soon as you come, you must pay back the money that was paid to you, illegally to you, and unlawfully. Thank you, Chair.
Your response, Mr. Pillay?
Sorry, can she just repeat that question?
Not the comment, the question.
Yeah.
Yeah, the point is that you must come back home and give back our money, taxpayers' money. But my question was based on errors made by the courts in paragraph 113, 115, and 116. Would you say the PP was well within her right to apply for appeal? And equally, should this committee rely on those judgments irrespective?
Well, I can only talk about three matters, and I've put the three matters before you. In the one matter, it's appealed right up to the Constitutional Court, and the judgments have been confirmed. On the second matter, we have heard today, and I think we've heard previously, that there's one matter that I am aware of, or rather I can remember, that the Public Protector's Office takes issue with. I don't know how that will come out in an appeal. And I don't know whether that one matter will change the whole judgment. And I'm not a lawyer. I think in the end, it won't change the overall thrust of the judgment.
Thank you.
And then I haven't integrated. I'm coming back to South Africa. Yeah.
Okay. Honorable Zungula.
Sorry, Chair, I missed his last sentence about South Africa. Sorry, Chair.
He said he's coming back to South Africa.
Or to give us our money back. Okay, thank you.
Honorable Zungula.
Thank you. Mr. Pillay, can we agree when I am covered with your answer, I can stop you so that you don't have to go on and on?
Yes. To you, Chair, yes.
Okay. So would you agree that the position of being commissioner or acting commissioner is equivalent of being a DG of a government department?
Yes.
Now, do you agree that DGs of departments have, for the longest time, needed to have a post-matric qualification of 3 years or equivalent?
I agree.
Okay. So why do you think it was proper for you to hold such a position that you agree that it is equivalent of being a DG without even having a matric certificate?
Well, the one thing I can say to you is that an assessment was done of all the members of the executive at that time. It was, we went through a battery of tests over 4.5 days. I think there was, I don't know, 7, 8 of us who underwent that test. And we called it the goodness of fit. I performed the best out of everybody in that test. I would say that assessment might have influenced the way Commissioner Opa Magashula saw things and the way Minister Godan saw things.
So this assessment, it was not independently done. It was done by your boss, basically.
No, it was done by Hay consultants from the United States who spent, I'm not sure, something like 2 months here in SARS, and they put most of the middle and senior managers through assessments.
Is it SACA accredited?
I don't know, but you know, at that stage when the tests were done, Commissioner Opa Magashula was our head of HR, and he's regarded as really a fundi in HR matters. I would say it would have been an assessment of quite a high caliber.
So basically, your experience has never been quantified independently by SACA?
No. The way I understand it is usually if you want to go and usually when you want to go and do further studies, then you go for such an assessment. Yes, I haven't gone to for such a formal process.
Okay, all right. No, as long as you agree that your position was equivalent to a DG, and the DGs have for the longest time required a post-matric qualification, which you did not have, and your experience was not quantified by SACA. So there is no independent authority which should be doing that work of quantifying your experience. So we agree on those points. But the next point would be, did you get your due lump sum on your retirement?
Yes, I got a one-third lump sum on my retirement.
Okay. Did you not perhaps think there's something wrong if you got your lump sum hardly because you had retired, hardly days, then you are appointed for somewhat the same position?
So, Honorable Member, the way I understand it is that retirement, which is retirement essentially from the pension fund and the rehiring, there are a few people where it has taken place in SARS, as was shown on the screen, but there are also thousands of people in the public service who were retired in that way and hired on contracts for a relatively short period and for sometimes specific projects. So it was really not that aspect of retirement from the fund and rehiring on contract is not a strange thing.
Okay, so what would happen if to the fiscus if all civil servants do that in our country? You know, all civil servants like you, they retire, get their lump sum, a day later they get to be appointed. What would happen to the fiscus? What impact that would have on the fiscus?
Everybody above 55 can take early retirement, is my understanding. I didn't take retirement at 40 or something like that. I took a retirement there. I took retirement, 2.5, 3 years shy of 60. It's an early retirement. And obviously the government and the fund manages things in such a way that these things are controlled.
Okay, so were the other people rehired to the same position, and did SARS pay the penalty and were they under 60? Because what I'm trying to ascertain here is that, is it a normality what the manner in which you retired, got the lump sum and were rehired? Was it something that happens only to you, or it was something that is a norm in our country when it comes to civil servants?
All right. So this one straight answer is that I don't know. What I know is that I wanted to access my money in the pension fund. So I wanted to retire from the fund. And I asked for to be rehired. And it's there apparently, and that's the key decision. If the early retirement is agreed to, that what kicks in is that the penalty is then paid by the employer.
Did I hear you correctly? You said you wanted to retire because you wanted access to your funds,
yeah,
and you wanted to be rehired.
Yes.
So it was something that you were in discussion with your the then bosses, that the purpose of you retiring, it is basically to get the lump sum. However, you want to be rehired. So it was something that is well planned. So as they're accepting you retiring, they knew that there was a plan to rehire you.
Well, I don't know about a plan to rehire me. It's a request I made, and SARS could have said no. You retire and you go. It's a decision that SARS had to make.
Okay, now let's move. So, in this retirement matter, did the court sanction you and Mr. Gordhan with punitive costs for accusing the PP without evidence of working with state capture operators?
Yes, there are certain paragraphs that were struck out, and there are certain costs that we were landed with.
Okay. All right. No, I think I'm done because I think for me what was important was the admission that you retired for the purposes of accessing your lump sum, and then you wanted to be rehired. So that is the most important, admission that you made. Thank you, Chair.
Thank you, Honorable Zungula. And I recognize Honorable Suela.
Thank you, Chairperson. I can't open my video because of load shedding. Greetings to you, Chair. Greetings to Advocate Mpofu and his team, and Advocate Bauer, together with my colleagues. I think I have got two questions which I want to pose to Mr. Evan Pilar. The first one is in relation with your investigation by the PP. Would you attribute the manner in which the PP handled your investigation and how she treated you, as well as the findings made by the courts, as the PP lacking the knowledge or skills to effectively perform their duties as a protector of the public? That's the first question. Thank you.
Through you, Chair. Thank you for the question. As I've said to, I think previously, the judgments are replete with comments about the efficiency and effectiveness of the public protector. And there are many times when it talks about irrational conclusions. There are many times when it says there's no evidence. There are many times when it says the evidence that we put forward was not taken into account. In both the judgments, more in the second judgment than the first judgment, there are very, very clear indications of the efficiency and effectiveness of the public protector. I think it's up to members then to say whether this is relevant for the work that they have to do in the committee. Thank you.
Thank you, sir. The next question still is in relation with the investigation. Do you think the manner in which the PP handled your investigations, she deliberately disregarded the law and facts to come to a predetermined outcome? What do you think led her to behave the way she did? Does this in any way indicate that she is pursuing a political agenda?
Thank you, Honourable Member. I've said earlier, I think there's a pattern in the way things are done, and I don't think the pattern only applies to my cases. I think there are a number of instances now where questions have been raised about whether the investigations are approached with an open mind. and whether evidence is assessed in the right way, competing evidence. And I think the judgments are very, very clear in many instances, but I wouldn't say in all instances, I don't know. But in many instances that the office has been found wanting. Thank you, Chair.
Thank you, Chairperson. I had only those two questions. Other questions have been covered by my colleagues. Thanks, Mr. Ewing.
Thank you.
Thank you. Before I go to the next speaker, I see your hand, Honorable Maute.
Yeah, no, Chair, you can take me after the last speaker, it's fine.
No,
You're taking me now, no problem.
Is it a point of order you want to raise, boss? You have spoken.
I have spoken here, but I want to say something for the record, Chair.
Honorable Gondwe.
Chair, are you going to come back to me? I'm asking.
I'm giving you an opportunity to raise your point of order.
Oh, okay. No, Chair, I was saying that since you're aware that Advocate Dalimpofu did not finish his cross-examination, I'm sure arrangements will be made for Mr. Pillay to come back so that Advocate Dalimpofu can finish.
No, that's not even a point of order. Thank you, Honorable Maute. I'm not going to entertain that. Honorable Gondwe.
Thank you very much, Chair. Good evening, Mr. Pillay. Mr. Pillay, you stated in the course of your evidence in chief that Mr. Gordon was not per se the primary target in the PP's investigation into the unit, but rather the capture of SARS was the primary target. Please expand on what you mean by this, and please take us into your confidence on who and why SARS was captured.
It's a long answer to this, honorable member, but I'll give you the short one. And in some instances, I'll be repeating myself, but I think we accumulated a large number of enemies over time in SARS. And they stretch on a continuum from disgruntled employees to taxpayers who were not who were serious evaders. It also stretches to political fixers and politicians, and it stretched to crime syndicates. And a big part of playing a big part in this is the tobacco syndicates. I think that around that time, 2014, came the perfect storm. Up to about 2013, we had some political cover. And it's important, we had a situation where Minister Manuel had been a minister for 10 years. And in SARS, we had Commissioner Godin for about that period. For institutions to grow and become effective, you need that amount of stability. But I think by 2013, 2014, we were about one of the last remaining institutions, together with Treasury and so on. Most of other institutions, in my view, were already taken over and they were dysfunctional, becoming dysfunctional. It was SARS and Treasury and some other institutions under Treasury that stood outside, in my view, outside the hands of the capturers. And it finally came to SARS, and then it finally did come to Treasury. And then what happened is that you had a big exodus from SARS, and you had quite a big exodus from the Treasury also. Thank you, Honourable Member.
Thank you, Mr. Pillay. Mr. Pillay, in the course of Mr. van Loganberg's cross-examination by Advocate Mpofu, this committee was shown a letter dated 18 February 2021, written to Advocate Mkhwebane by the current SARS Commissioner, Mr. Kisvita, wherein he informed her that SARS would be relocating with equipment forming part of, her investigation into the alleged rogue unit. Which equipment had been securely stored in the basement under the supervision of DPCI, the SSA, and SARS. What do you know about this equipment? What sort of equipment was Mr. Kiesvetter's letter, referring to that was stored in the basement under the supervision of DPCI, SSA, and SARS?
Okay, so Honourable Member, the first thing to say is that equipment is not equipment that can be said to have belonged to the investigation unit in question. It's not true. I would say it's a lie. So that's the first thing. The issue of the equipment is dealt with in some length in the judgment of the second investigation. They really go into it in great some length. And it says that allegations about the equipment, no evidence has been presented by anybody and by the public protector to say what is this equipment and where it is. In fact, the judgment is very critical because the public protector is saying, because you are a unit doing unlawful things, you must have equipment. Therefore, if we can't find the equipment, you're hiding it. So there is equipment of some sort, which was bought by the Security and Anti-Corruption Unit for SARS. They used that. It was not used by a unit, and it was used for security purposes in SARS. There's other equipment that is talked about, like night visions and so on. This is equipment delivered to SARS after 2014. And this equipment comes from the United States Customs, who provided this equipment to SARS Customs. There is no equipment that this unit has bought, and I provided to the Skakani panel the report of the CFO, who said there is no such procurement. And in fact, the Skakani report says, by the way, this is early now, so this is in 2014, end of 2014. Skakani report says, we found no equipment. They actually say, it must be said, we found no equipment. So this equipment is one of these things that is bandied around, but there is no such equipment. Thank you.
Thank you, Mr. Pillay. Mr. Pillay, we heard from one of the witnesses, Mr. Ibrahim, that the office that Advocate Mkhwebane occupies requires and demands a high level of responsibility, professionalism, ethics, and impartiality and independence. So my question to you then becomes, in your view, and in light of what has transpired between her and yourself, do you think that Advocate Mkhwebane has lived up to this responsibility that her office requires and demands?
Through you, Chair, Honourable Member, it's difficult for me to make take a general position on these things, because really then one has to look at all of the activities and all of the cases, and one would have to, on balance, take a view. But equally as important is to say, what are the policies and procedures what are the investigation manuals, what's the manual about complaints. These will show what is the way in which these things are handled in that institution. So one is really what's the practice and what's the performance like, and look at it in the balance. But the other is are there very clear policies and procedures about how complaints are handled, what complaints are really investigated. When investigations start, that this is how it is done. How do we ensure that the investigation is done properly? We don't have findings that are always overturned. Thank you.
Thank you, Mr. Pillay. Mr. Pillay, I'm asking the next question on the back of the third report. Does it appear to you that despite being admonished by the courts in the review applications, Advocate Mukhabane is determined at all costs to prove that the unit was rogue and was established and operated under your guidance and management in a manner that contravened our country's intelligence laws? If your response to this question is in the affirmative, please confirm why you think she's determined at all costs to prove that the unit was rogue. What does she stand to gain from coming to such a determination and implicating you and others in relation to the function and the workings of the unit? In simple and blunt terms, does she have some sort of a grudge against you or a vendetta against you? What exactly is going on here?
Honorable Member, look, so let me get clarity. So the third investigation is actually about procurement IT, which investigation was begun in SARS by Tom Moyane. He had started a project called Project Line and focused on the IT part. So that was obviously, in my view, was a way to take control of the IT capability in SARS and to get rid of the then head of IT, Mr. Barry Hall. We had one of the best IT shops, IT capability in the whole of South Africa. So that is the third one. It puzzles me. I don't know the answer because no notice, no single engagement. She went through the whole process and there's a finding at the end of the day, which I read about in a newspaper. I then get hold of the legal team that has worked with me to say, guys, can you find out for me? Can we get a copy of this? I believe that there's a finding here. So for me, it's very puzzling when in two judgment, one gets seriously criticized. And then in the third investigation, one doesn't do the most basic thing, which is inform the other party of the allegations. It is really, really puzzling. I just can't fathom why it is so. I can fathom why there was an attempt to breach the walls in SARS and take control of SARS, and why there was an attempt to take control of the treasury. But why in 2019, 2020, 2021, to continue with this beats me. It really beats me. I would really love to. I know with all this talking about bugging, I should be very careful, but I'd love to be a fly in the walls when these things are discussed, to really understand why this was done. It's the most basic thing that one should afford one's, if you want to call it one's adversary.
Yeah, I think that you have answered, Honorable Gonda, your last point.
Thank you very much, Chairperson. In paragraph 10 of your affidavit, Mr. Pillay, you state that you've been embroiled in endless litigation with the PP for a number of years at a great cost to you. Please take the committee into your confidence regarding, this cost on a financial and a personal level.
Chairperson, sorry. We've already had the evidence that it's 4 million rand. I mean, we're having questions being asked that have already been answered.
Okay, thank you, Honorable Aaron, for raising that. Yeah, let's complete it. We're at the end.
Chair, I think Honorable Heron should just allow me to ask my questions.
Sorry, Chair. Sorry, the directors are very clear
Please
about
don't interrupt.
asking questions that have been asked already.
Thank you, Honorable Aaron. Let's complete it. I take your point, Honorable Aaron.
So should I answer, Chair?
Yes.
Yeah. The number that I was given was approximately 4 million. That's the approximate number, which is the costs. That's not the whole costs for us that we have experienced since 2014. That's another matter. Thank you.
Okay, thank you. Thank you. Mr. Pillay, I just have 3 quick clarity questions, and I'm going to guide you so that we don't go too long.
My hand was...
Oh, sorry, before I come, Honorable Laguda, you're correct. Come. I almost forgot you with this load shedding, you're in and out.
Okay, thank you very much, Honorable Chairperson. Good evening to you, my colleagues, the Public Protector and her team, our evidence leaders. Good evening, Mr. Pillay.
Good evening.
We really appreciate you availing yourself for this process. Mr. Pillay, when you were being cross-examined, you made mention that the high-risk unit, which is called the rogue unit, was not spying on anyone. So I want to know, how did the formation of this unit assisted the state in dealing with criminal elements?
Yes, thank you, Honorable Member. As I said, this unit in its lifetime has worked on 81 projects. After the first year or two, it was reduced to 7 people. So it's a small number of projects, but it did invaluable work. It did that work which a normal member of SARS wouldn't want to do. Because remember, SARS is essentially a civilian organization, and quite a bit of transgressions, especially on the customs side, is done by organized crime. And many normal SARS, ordinary SARS members wouldn't want to operate in that space. So they were prepared to work in that space and prepared to take a little bit of risk. And these were people who could take care of themselves and not expose themselves needlessly to risk. A lot of the work that we worked on was on drugs, cigarette smuggling, making and manufacturing of counterfeit cigarettes, abalone. I can't remember all of them now, but when we started with a focus on 5 parts of the illicit economy. And I should say that it was very important in these 5 parts to understand it as the whole value chain in that business, like abalone. And then try to intervene in a way in which puts pressure on the value chain. Thank you, Chair.
Thank you very much, Mr. Pillay, for that response. In your tenure at SARS as the Deputy Commissioner, were you in any way pressurized by politicians to do your work in a manner that will compromise your principles?
It happened on 2 or 3 occasions. It didn't happen on more occasions because we made an early decision to live our lives in such a way that we would not, in the ordinary course of socializing, be in situations where we would be put under pressure. So there were instances, one very, very early on, and I said to this very senior person, we are prepared to help, but we can only help according to what law permits us to do. There was an attempt to say, let's target so-and-so. What can you do as SARS? On 2 occasions was raised with me, and we said, no, we do not do that. We act according to the law, and if you want information from us, you should request it in the normal way in which the law allows. So there were, I should say, not many instances. There were a few instances. Maybe for me, in my own understanding, there were about a handful. There were a few others with others, but generally we worked in such a way, our policies and procedures were good, our processes were good, our checks and balances were good. Of course, people would have broken through, but they would have been the exceptions. Thank you.
Thank you very much, Mr. Pillay, for that response. After that interaction with the senior person, as you were saying, what was your relationship with that particular person after you refused to accede to the request?
So, Honourable Member, let me tell you what I did. I didn't refuse outright. I said, we are prepared to help, but we can only do it according to the law. And then a week later, he sent me an emissary. By the way, he happened to come from the intelligence agency. And he said, look, so-and-so sent me, there's things that you can help. And I said to him the same thing. I'm prepared to help you. We've got to do these things according to the law. And I can really help if your person will come clean and disclose everything. Because the law allows us, and our policies and procedures allow us to be more lenient with somebody when they are cooperating with us. That was the last that I saw of that emissary. Never came back.
Okay, thank you, Mr. Pillay. Then you also made mention just that because of the so-called rogue unit, you made many enemies. Were there lives that were lost because of this? Or maybe I can say, were people's lives in danger because of the so-called rogue unit's work?
Yes, there was some danger, and I think Johan van Lochenberg spoke about that. A few people were killed. I wouldn't say that that was linked to any sort of necessarily political inspired incident, but there were attempts which I believed to be more criminal than politically inspired. But there have been other incidents of housebreaking, breaking into cars, stealing computers. That has happened to a fair number of people. Thank you.
Okay. Mr. Pillay, how did you become aware of the third report since the public protector didn't give you any notice or subpoena?
I saw a report, honorable member, in the newspaper saying that the public protector has completed the third investigation and she's released her findings, and she's found findings against, I think it's about 5 of us. And I saw my name there. I think I saw my name there, or but what I did is I contacted my lawyers to say, can you have a look at this? Now, I was aware that there was an investigation. I was aware because Perry Hall from Abashula. I didn't know from Mr. Praveen Gordhan, because I hadn't seen him in some time, that all of them had been contacted by the public protector on this matter of the IT procurement. I had expected her to contact me at some stage, because I was also at SARS, but she didn't. So I saw it in the newspaper, and then it was confirmed by my lawyers. Thank you.
Why do you think, if I may ask, the reasons for her not notifying you about this investigation?
Yeah, as I said, it's a question one of your colleagues asked. It baffles the mind. Because it's the most fundamental mistake to make.
Okay. My last.
Sorry. Yeah.
Okay. My last question, Honorable Chair, to Mr. Pillay. When you responded about the people who were working in the so-called rogue unit, you said there were people who were capable of taking care of themselves. So, from the security point of view, I would think by that response of yours, these people were highly trained, and they were highly trained to take care of themselves, and they work undercover like spies. Is this true? My assumption.
Chair, through Chair, the people in that unit, many of them came from the Defense Force and from national intelligence, from foreign intelligence, from some of them from police intelligence. So they had a background in intelligence. There would be no point in creating a unit to work on the illicit economy that didn't have an intelligence background, and that didn't have the capability to avoid risks. So for me, it flows. They had the capability. And what is true, and I want to be very precise about this, they were shielded in the sense that They didn't operate openly in SARS. Not everybody knew them operating there, but they were registered SARS employees. So if people went into the SARS files, they would see their names. But these were not people seen every day in SARS offices.
Okay, thank you very much, Honorable Chair. Thanks, Mr. Pillay, for your responses.
Thank you.
Thank you, Honorable Dlakude, and thank you to you, Mr. Pillay. Perhaps just the last few clarity questions, and I said just 3, I might make them 2. The first one, Mr. Pillay, is in respect of the 81 projects. What was the benefit to the Republic of the 81 projects?
Thank you, Chair. Chair, I could even make a request later that we can send you reports about the 81 projects. But the benefits were that we confiscated tons of tobacco.
Tons of what?
Tobacco.
Okay.
Smuggled tobacco, tons of counterfeit cigarettes. We really hit them hard. There are reports, and I'm sure Mr. van Lochenberg can provide them, some old reports, but I'm sure a request to SARS can show that. Very, very early on, there was a big drug bust in the Natal area that this group was involved in. We did a lot of work on Abalone. But the key thing about it, as I was saying, is that we try to understand the business. What's the business and how to choke the business. And in the result, we disrupted the business. Where it was possible to get people arrested, we did, and we confiscated products. Thank you, Chair.
Okay. Thank you. My next point will go, and I'll want to flight bundle F, number 70, which will be a letter from SARS. I want you to take you to the last paragraph of that letter. Mr. Pillay, you might not have it, but we'll quickly assist you. Are you winning, Tsepo? Just start from the top and show it and then go to the bottom.
Oh, well, then yes, madam.
So this was would have been the letter. You see who it was sent to and copied. Go to the last paragraph. So, last paragraph. So perhaps let's go to point C. Point C says the equipment in question was not procured nor used by the high-risk investigation unit. Is that your understanding?
Indeed, it is.
It was procured in line with SARS procurement policy and used by a unit as well called the Anti-Corruption Security Unit, currently known as the Anti-Corruption Unit. Is that your understanding?
Indeed, it is so. It was so, and it is
It was so, and it is so.
Yes.
So you agree with that assertion?
Yes.
Okay. Thank you. Can remove that. My last point.
Chair.
Advocate Mbofu. Yes, Advocate Mbofu.
Okay. No, I'm sorry to interrupt, Chair. I just want to know what's happening now. Are you leading evidence?
No.
What's happening? Well, what is this? And which rule are you allowed to bring new evidence now? Are you an evidence leader, Chair?
Thank you, Honorable Advocate Mbofu. You know that I'm not an evidence leader, and there's no new evidence. This is all in the bundle F which you have.
Yeah, but I've not seen it, and I don't know. But yeah, I haven't seriously.
All of us have.
I accept that it's in the bundle, but I have not seen it.
So thank you. It's accessible in bundle.
Can it be led through the chair? No, I just want to know. I'm being serious, Chair. Can it be led through the chair? Is this the kind of document? Because I don't know what it says here.
Okay. Thank you, Advocate Mbofu. We will attend to you on that. I'm going to my last point.
All right.
My last point, Mr. Pillay. Colleagues would have touched this. I just want to deal with 2 points on this. And briefly, were all these positions where people were rehired, advertised per the policy?
It's a good question.
Yeah, I know.
I wouldn't know. I think we should ask it of SARS HR to give us clarity on that. But I cannot point you to anything to say, here's a policy, etc.
The question is in 2 parts. So the first part says, where these positions where people were rehired advertised as per the policy. So you wouldn't know if it was advertised. So does it mean that you did not apply?
Well, normally, like for example, say Mr. Kosi Low, or the first commissioner of SARS who was rehired on contract, they're normally appointed as specialists. Normally, that's how it's done. I don't think it is advertised because there is an allowance in SARS policy for the commissioner to appoint people, and by the way, any other senior manager, they apply for, that's right, they apply for an exemption to HR, and then from HR to the commissioner, they apply for an exemption to say, this is a person who's here, this is what he's done, and we want him, and then it's done according to an exemption. So in other words, I must correct myself, there is a system, it's an exemption system, and it's usually recorded as an exemption rather than pretending to go through an advertising process.
In your knowledge, did they compete with other applicants and got these positions on merit?
Chair, they would not be competing because the positions would not be advertised. The appointment is on an exception basis.
Okay, all right. Thank you for your responses there, Mr. Pillay. I just wanted to place those issues for my own clarity on record. And at this point, I'm going to invite Evidence Leader Advocate Bauer. If you have any questions to the witness.
We have no further questions. We know the arrangement was that Mr. Pillay would avail himself for today, and we can't way over time, and we indebted for his time. Thank you.
No further questions. Thank you. Thank you, Advocate Bauer. With that, colleagues, we have reached the end of our interactions with you. Do you have anything to say, Mr. Pillay?
Mr. Chairman, thank you. Thank you for inviting me here. And I appreciate the questions and the attention from the members and the evidence leaders.
Thank you. You are now excused.
Thank you.
Thank you, Mr. Pillay. Thank you, honorable members and colleagues. We adjourn our meeting.
Thank you, Chairperson.
Till when, Chair?
Recording stopped.
Thank you. Till Wednesday.
Okay, Chair.